Right, good morning everybody. The time is now 9:30, so this inquiry is now resumed. So for those people that don't know me, new faces around the room, my name is Helen Harkenhull. I'm a Chartered Town Planner, an Inspector appointed by the Secretary of State for Levelling Up Housing and Communities to hold this inquiry into an appeal made by Brandon Estates Limited for the demolition of existing buildings and outline planning application for residential development, including access, open space, sports pitch, pavilion and associated car park on the site of the former Brandon Stadium on Rugby Road near Coventry. So as per usual, just a few reminders, housekeeping matters. Mobile phones, please turn them off or on silent. Also laptop notifications, you turn those off as well, then they don't distract us. Anybody intend to film or record the events? No, we have the press here. Good morning to you again, joining us this morning. Fire evacuation, I'm not aware that there is to be a fire drill today. So if the alarm does sound, we are then asked to make our way down the main staircase, out of the main doors of the town hall, and then to congregate at the entrance to Caldecott Park. And then an officer of the council will give us instructions when it's safe to come back into the building. So a few matters just to pick up on before we start this morning. A couple of things on my list from yesterday's cross-examination and evidence from Mr. Carter. Mr. Carter, you were going to look up a reference for employment figures. If you recall, you were going to see if you could find a reference for us. Were you able to do that?
Yes, I was, Ma'am. If you just bear with me a second.
Okay.
The reference to employment is in CD 10.19, which is the objections that SCS submitted on the revised planning application at para 8.3. The information I gave yesterday was more detailed.
Yes, it was.
Breakdown than that. And I said 4 full-time, whereas there were 5 full-time in the original one. That was because one of the part-time staff worked something like 35 hours a week, not a full week, so they were counted as part-time at that stage. There's nothing more to it than that.
Right, okay, that's fine.
Thank you.
Thank you. And the other question, I think that the council were going to just check up on the adoption of the local plan and the neighbourhood plan and let me know the outcome of that consideration.
Yes, I'm 99% certain that I know the answer.
Good.
And it's going to be that the notice of adoption, which is the legal instrument, was they were published at exactly the same time, but I'm just double checking that.
Okay, all right. So I think Ella she's nodding behind you.
Yeah, that's right.
Oh, that is right.
That is
I'm now 100% certain.
I guess that 1% is all important. Yes. Okay. All right. Thank you. And that when was that exactly? Do we have a date for that?
4th of June. We'll give you the date.
Or a month will do.
They were published
June.
on the 28th
June 19.
of May.
Oh.
28th of May 2019 was the agenda date. The council date was the 4th of June 2019.
Okay, so 4th of June.
4th of June, 19, yeah, okay. That's fine, thank you. Right, the other thing I want to pick up on this morning was something we started discussing yesterday, and that was the roundtable discussion on planning obligations. Yesterday, we all received a speaking note from the advocate representing the NHS Trust. I've had time to have a look at that and consider it overnight, particularly in relation to procedure and where that takes us. Before I give my judgment, though, I would just like to see if parties have any views that I may need to take into consideration. So, Mr. Richards, do you have any view on this?
I'm wrestling with the desirability of making progress, with the desirability of you being able to make or reach a conclusion that is likely to be legally robust. They're not here at the moment, but you will know that certain parties have not been backward in coming forward when it comes to issuing High Court proceedings. And we don't want that in this case. So I'm trying to wrestle with a short delay to enable you to have the information you need in the most digestible and helpful form and tested in the most appropriate way, and with making progress which is in everybody's interests, including the public interest. Now, one thing I don't know is what sort of delay switching procedure might entail. If you like, the three of us could put our heads together. I'm coming towards the end of a series of inquiries. But I don't know what the other position the others are in. Now, I don't know if that assists you or makes matters worse.
No, it doesn't make matters worse. I will say that. Mr. Humphreys, do you have any? You don't wish to add, right, Mr. Goatley?
Ma'am, no, nothing of substance to add. You will see that there is what is described as a blue pencil provision within the obligation. So I recognise the position of the authority, and that may be different from the position of the appellant in terms of what might be characterised as the expediency of dealing with matters. Now, to that extent, we would not be anticipated, so far as the NHS contribution, to be likely to be directly involved in many of what might be the most testing elements of the exploration of evidence. That does not mean to say we're disinterested. Clearly, we're not disinterested in that, and I would clearly reserve my position of being able to involve and intervene if that were appropriate. But that's not where we principally are. It seems to me it's most materially a matter between the local planning authority and the NHS Trust.
Okay, thank you, Mr. Goatley.
I mean, and if I could just add,
Yeah.
It may be thought that the sum asked for in this case is neither here nor there. It's not affecting, for example, the viability of the scheme such that other matters which the local authority would want to receive by way of developer contributions have to be sacrificed. But such a case may arise in the future, and therefore the council has an interest in not setting in effect what would be a bad precedent. Now, the Worcestershire case ended up in the High Court because the sums went into millions. Other cases in Worcestershire, proceedings were issued and then the developer paid the money and the claimants went away. But this authority is not wanting to end up with that sort of thing in its borough, and therefore is doing the intellectually and legally honest thing and telling you that we don't think they're still compliant.
That's helpful. Thank you, Mr. Richards. And I can certainly understand, in this case, that the sum of money is 133,000, which is not insignificant, but equally there is a principal issue for the council here, irrespective of that value. My view at the moment is that, well, initially, I think the initial request I had from the council was the day before this inquiry started, and the indication that somebody from the trust was going to attend the roundtable discussion just to debate that particular issue. It appears to me that that has now been escalated over the last week or so, with other parties now being involved, in particular an advocate for the NHS Trust and the speaking note that was provided yesterday. My view is that is not appropriate to be dealt with in a roundtable discussion. And it may be I'm erring on the side of caution a little bit, but I do have, as you say, we are wrestling here to trying to be efficient and secure a decision for the appellant in a reasonable period of time, but also we want to reduce the risk of challenge as well, so I'm sure you're aware of that. So I think my view is that the most appropriate option is not to address that through a roundtable and to have that particular element the subject of witness statements and then cross-examination, which unfortunately will mean a delay. So I apologise for that, but I think in the circumstances that is probably the most appropriate way forward. So it would be helpful if we can try and reduce that delay as much as possible. and arrange some suitable dates where everybody is free to reconvene. So we're probably looking, I would suggest, maybe 2 further days to be on the safe side. Really, we'll need closing submissions and the debate on that particular issue with all parties. As I said, if we can arrange a date as soon as possible. I know we're all extremely busy. I have lots of things in our diaries. But if we can arrange a date as soon as we can, then I think that would be really helpful. So if you could take that forward from there. I would like to try and get a date in the diary by the end of tomorrow or tomorrow lunchtime if we can before we go away, so we all know where we're going.
I realise I don't want to lose time today unnecessarily, but I'm conscious that in reality, other than I think Mr. Osborne's evidence tomorrow, I think that's going to constitute, together with whatever is said otherwise, that's probably going to constitute the end of play. I don't know whether or not we're going to get further than that. What I was going to suggest is whether or not it may be desirable now to just have a quarter of an hour, one, for us to be able to make any arrangements between ourselves as to likely time dates, because I recognise the person whose time is most precious to this is yours, and what's in your diary, not just ours, but also if steps could be taken both with Mr. Bowes' clerk, particularly if he's going to appear, to find out when, if he would be available. So if we had a quarter of an hour now, rather than necessarily leaving it to a later stage, it may be that steps can be taken to try to narrow down what the likely time return. Let me be clear, ma'am. I make no complaint or criticism about the approach that you've taken. I recognise that. I think I foreshadowed that yesterday in terms of my observations. But equally, we have an interest specifically in not seeing time go by, and this is beyond really the powers of anyone that's in this room. They do. So if we had 15 minutes now, I think that may be helpful.
Madam, 2 points. First of all, I'm not sure whether I'll be able to attend for my clients extra days, irrespective of whether I'm available. Second point, just before I forget, one of the outstanding housekeeping matters of further information that you're awaiting, not just from us, we've given you it, but Mr. Eady was going to come back on the distances. So I don't know whether there's any progress on that.
We have. I saw an email about 5 minutes ago on that. So I was probably going to ask. I was otherwise going to ask Mr. Hooper to actually set that out when he gave evidence. So yes, that's in mind. But in the overall scheme of things, I think sorting out what we're going to do on the round table or not round table tomorrow is probably higher up the pecking order.
I'm happy to have a short break just to enable some discussion on this. So if we take a break then until 10 o'clock. To give everyone the opportunity, and I'll have a look at my diary as well during that time. Okay, so we'll adjourn then until 10. Thank you. Right, thank you very much, everybody. It's just after 10 o'clock. We've been having our conversation about dates. So we're just waiting to hear back from one party, whether they are available. So we'll leave that for now and come back to it. So we'll go back to our agenda for this morning. Mr. Humphreys, I believe Mr. Rees is available. So if we'd like to... Good morning, Mr. Rees. It's really good to see you. I hope you're feeling a lot better. Good. Well, it's very, very good that you're able to join us today. So we're going to start off this morning's proceedings with your evidence, please, Mr. Rees. So do you want to sit there, or what we've been doing is witnesses have been sitting on the front row there and then using the microphone. So, yeah, if you don't mind just going to the middle there, then you're sort of in central position then. Thank you. So the microphones, all you need to do is push the button that says push to talk. Hopefully that's it, yes, and then you're turned on. Okay then, so, Mr. Humphreys then, do you want to, it's not a witness, is it? Yeah, sorry. I'm getting ahead of myself, sorry about that. Yeah, so Mr. Rees, when you're ready, do you want to read out your statement that you've submitted, and then if you're amenable, I'm sure Mr. Goatley may have some questions for you.
Yeah,
okay.
That's fine.
Right, thank you, Mr. Rees.
Just by means of introduction, I'm the chairman of Brisker Formula One, chairman of the Oval Racing Council, which is the main guidance and governance body for all oval racing. Been a promoter for 30 years and a competitor at Coventry. Not very successful because I kept crashing, but I've been in the sport for over 50 years. I currently chair both associations and as a former promoter. On behalf of the governing bodies, we are diametrically opposed to seeing Brandon redeveloped for housing, and the loss of Coventry has left a huge void in the sport, not just for stock car and oval racing, but obviously, as has been much discussed over the last week, Speedway in the Midlands. Without entering the politics of what happened at the end of 2016, because we were also operating stock car racing at Coventry Stadium 2016 and prior. Obviously, we had to terminate at the end of 2016, and then we're at a stage where, obviously, we're at now in terms of development. From our behalf and the sport, and on behalf of the competitors and the many people who follow it, we wish to see the stadium restored to its former glory. It was an iconic heritage prestige stadium within the sport, and it to once again hold regular stock car racing events, and of course welcome Speedway back as well, because the two sports work in tandem and give maximum usage to the stadium. We want to see the major championship events return there. It has historically staged most of the sports, if not all the sports, major events, including World Championship finals, and other classes of Formulas too, because oval racing isn't just about Brisker Formula One. There are probably about 15 other race divisions, right down to juniors, who we feed into the sport that are very, very important. The facilities at Coventry were absolutely second to none in what it offered, and particularly after some significant investment by Mr. Sandhu. It's not a politics which I don't want to end in, but it's effectively now degenerated in terms of its fabric and structure, making the restoration far more difficult and creating an environment where it is obviously going to be a major hurdle and costly to reinstall to how it was. Crucially, the main infrastructure to allow racing to return to the stadium remains restorable in terms of the track and some of the safety provisions for racing. Those are reasonably straightforward to return the track. But I've been following the case over the last week. There is an urgent and pressing need to restore the stadium. Many of the arguments you've already heard, I can only echo, so the sport can once again return on a regular basis back to sort of the West Midlands. The council have done their bit in terms of local people, local competitors, local councillors and it's about hopefully rejecting the proposals so we can move forward and restore the stadium.
All right, thank you, Mr. Rees. Now, we have received a statement from you that goes into some more detail of your views, and we have obviously had the opportunity to analyse that. Can I ask Mr. Goatley, is there anything you wish to ask Mr. Rees?
Yes, please. Thank you, ma'am. Mr. Rees, good morning. Mr. Rees, thank you. If you can have that available to speak to. Thank you very much. I've got 2 bits. I've got 16.4.1 together with a letter attached. No, that's one. That's his submission to the inquiry. Mr. Rees, you tell us at paragraph 5 of your statement that the sport currently operates from around 20 venues between Aberdeen and Cornwall. It's fair to observe that there is no lack of locations where stock car racing can be undertaken by those who wish to undertake it. Would you agree?
No, I wouldn't agree with that one. I mean, the sport relies on areas. I mean, yes, we've got, I think that the thing I was trying to illustrate there is the sport are still robust with a number of venues that proves the support for it. But in main areas, like the West Midlands, that's got huge conurbation, a lot of families that are close to the sport, a lot of competitors, it's missing. And people cannot afford to travel, and fans are lost by travelling distances. So I think what I'm trying to rebut in that point was that the sport is not, as many people are saying, dying. It still thrives and exists in different areas, but the West Midlands is now missing.
Now, in terms of numbers, first of all, numbers of participants at each event, is that something where there is any data set that you can assist us with as to how many participants are taking part in any given event that you can refer to?
I can get data together.
No, it's not a case of getting data together. This is the inquiry. Evidence was to be produced 4 weeks before this inquiry starting last Tuesday. This is not an opportunity for backfilling.
Okay, well...
Data sets, you don't refer to any data for how many spectators there are, correct?
Correct.
Nor participants?
No, but I can answer participant levels from events I've promoted. For example, if I stick to Brandon Stadium that we last operated in 2016, we were on the events that we were staging regularly attracting an average of 150 competitors, which was the maximum. We could have had more competitors. It was the maximum we could actually accommodate with the space and size and the parameters that we got.
Excuse me, were you the promoter at Brandon Stadium?
Yes, I was. For non-Formula One events. Coventry Racing Club ran the Formula One stock car events. We leased the track from them.
Right. And what was the cost of your lease to obtain the track?
We paid a rental per event that we were there and the on-the-day costs.
And what were those figures?
Well, the rental cost for the stadium that we contributed was £3,600 per event. And then on top of that, obviously, we had the on-costs, such as insurance, liability insurance, the track, the cost of operating the event, etc.
Right. Are there any accounts available to us as to how those events would work and whether or not they were viable in financial terms?
I can provide accounts from our accountants.
No. Well, same point again, because none of those matters have ever been advanced.
What I can say is all the events that we operated there were viable.
Right. In terms of number of spectators attending, you're not able to assist us with that. Correct?
I can tell you what we had, but if you want it in documentary evidence, I mean, our average attendance for the type of event that we were running was approximately 1,500.
Yeah, well, you tell us that average 1,500, but there's nothing to indicate how many turned up to X event or Y event and how often they turned up to those events. That's correct, isn't it?
I cannot give you the actual figures or accounts today, but I can tell you the events will run once or twice a month between March and November, and including Christmas.
Now, you tell us about a lot of families, racers, can't afford to travel. Has there been any survey of either participants or spectators as to their ability or otherwise to attend other venues or attend this venue and why they are not attending other venues? Is there any survey material?
There is no specific survey, but we operate in that business with drivers that regularly license and fans, and there is plenty on social media. That's why live streaming is becoming more and more popular, because of the inability of people to travel based on costs.
Stock car racing, do people only race from one stadium?
That varies by the type of formula. Some formulas, because we start from juniors from 6 years of age upwards, we've got many entry-level sports, so a number of formulas may well be generic or to the hinterland of a particular stadium because they're local. You have more, you progress through the ranks of formulas like Brisker Formula 1, Brisker Formula 2, etc., where there is more travel involved. But again, the travel doesn't enhance the number of competitors because of the extreme cost of it.
If you're going to be a competitor, explain to me, if you would, how for the sake of argument, a Formula 1 team arrives. Do you just drive your stock car to the track and then start racing? Or does it come on a low loader, for instance?
Formula 1 is probably the elite of over-racing formulas by cost and definition. A Formula 1 stock car can cost anything from £50,000 upwards and does come in a race transporter to an event.
Are stock cars road legal vehicles?
No.
So any vehicle that is coming to a stock car race is going to have to be transported there by some form of transporter. Is that correct?
Yes, whichever formula you race.
Yeah. If one was moving to any other location, whether or not it's 100 yards down the road, or whether or not it's 50 miles or 100 miles down the road, you're still going to have all of those elements for the purposes of carrying out that journey, aren't you?
You would have to have the equipment.
Yeah.
Yes.
So the only difference is the petrol cost, or diesel cost as appropriate, of going from whatever home location might be to the location of the track and back again.
I think I understand the point you're trying to make, but I don't think it's as simplistic as that.
Well, tell me what would be the additional on cost of going to an event elsewhere beyond that which I've put to you?
Well, for example, in many of the, should I say, the more budget formulas that are far cheaper to procure a car, can be brought on a trailer on the back of a car, or with sort of minimal. It is the cost of competition. You know, these are families, hard-pressed families, as we know, so they're restricted to a geography. When you're talking about the cost of fuel now and how much a transporter you will consume in fuel to get to an event, it is restrictive because the further you've got to travel.
Yeah, so you've got to travel there and travel back, and then there is the fuel in the event itself, presumably.
Yes, there's race fuel for the cars.
And so for that, they will inevitably be consuming fuel for those purposes, yes?
Yes.
Yeah. So the reality is that it's only the travel costs. Again, those are not the subject of any kind of cost breakdown in order to indicate what the cost is per mile and why that suddenly becomes unacceptable for any of the tracks elsewhere rather than here. We've not got any information on that, have we?
No, but I think that the major point to that is the demographics of the sport. What you're raising is reasonably accurate. The driver's got the equipment, he's got the car. The impediment is how far you've got to travel with it. I've sort of get the point that you're making. However, the fact that we continue to lose venues is having a major effect and drag on the sport, because travelling those distances, many do, and you know we're extremely grateful for that. But it is draining on the sport, and it isn't just the fuel costs. There's families that live within areas and what's an acceptable, reasonable distance to travel.
Yeah, and we have absolutely nothing by way of a survey or other data set in order to explain what that particular impact is said to be, either in terms of numbers of participants and their teams, or for that matter, the costs which they are incurring. We don't have any of that material, do we?
We've not been requested for that information as yet.
Well, I haven't requested anything, I've just asked for it, asked whether you've got it, and you haven't. So in terms of that, we don't have any of that information, because in just about every sport, people will travel for the purposes of competition, whether or not it's athletics, whether it's equestrian, whether it's football, whether it's other team sports. They will travel from location to location to location, won't they?
You are sticking here to the competitor. What about the many, many, many thousands of people who are families, who attend the sport and enjoy it? And, you know, we're talking about significant people here, who in areas, and in this particular area, have lost their sport and their activity. You know, some will travel, the greater majority have not got the ways and means to do so.
Yeah, well, we have no information on that, do we? On spectator numbers, or spectator numbers who are not able to travel. That is just pure assertion on your part, isn't it?
I wouldn't say it's assertion. I would
Well,
say
it is assertion if I can't say that this is what the position is and we're able to test it. If it's not capable of being tested, it's assertion.
I would refute that. I would say there's common sense to the fact that people cannot afford to travel out of area.
Common sense beg your pardon. Common sense is just simply what's used as a stock answer for people who actually don't have an answer, because there actually is no information which you have available on this. You just simply assert that there are people who are hard-pressed families who are unable to travel. We don't know how many, we don't know who, we don't know where they don't travel to, why they were travelling to Coventry. Were they in Coventry? Were they at Rugby? Were they somewhere else and travelling to that location? Are they now travelling to another location because they're no longer travelling to that location? We don't have any of that, do we?
I've not got evidence to supply.
No. As far as participants are concerned, Mr. Carter was able to identify perhaps 2 local stock car racers who may no longer be participating subsequent to the closure of Brandon. Do you have any information as to how many stock car racers are not racing because Brandon has closed?
Not that I could present in the documentary form that you appear to wish today. I would again be given assertion that there are quite a number, particularly of the more localised formulas. There are several Formula Ones. I'm aware Mr. Carter has identified them because there was a significant number that did Coventry only because they lived within sort of 30, 35 miles of it. Where the bigger loss has been is in terms of local people in what were more localised formulas like banger racing, junior formulas that have not only lost Brandon but lost Birmingham Wheels as well.
Right. And we don't have any numbers on that either?
No.
Nor do we have any numbers on spectators, would that be correct?
I think Mr. Carter's given numbers on spectators. When
no, what we don't have is numbers of spectators who are no longer spectating, having regard to previous spectator attendance of stock car by reason of the absence of Brandon. We don't have any of that information.
No, all I can say, there's a lot of people that cannot go any further for different reasons. How we would actually possibly ascertain that information if challenged to do so, as they've left the sport, we would have no way of contacting them.
Do I take it that you thought that 30 to 35 miles was a normal travelling distance for someone who was local to the Brandon Stadium?
No, a number of people travelled a lot further than that.
Now, you speak as, in your paragraph 6, about no oval race venue has closed on viability grounds. Over, say, the past 30 years, have oval tracks closed?
Yes, I lost 2 of my own in 2019.
Yeah. And did they close on viability grounds?
No, on what you would describe as tenure grounds, where you're not in control of the site. They suddenly become more valuable for redevelopment, and the sports were actually viable there, but the stadium's got more value on redevelopment. Bellevue went for housing, and Stoke for redevelopment for industrial units.
Well, Bellevue was the subject of effectively a replacement venue at something over £13 million to the Manchester ratepayers, wasn't it?
That would be a very long and complex story. Stock car racing were not invited to go next door.
Okay. If stock car racing were such a viable and profitable enterprise, you would expect to be able to provide a rent incentive to a landowner, such that a landowner who is the stadium owner would actually keep that stadium running. Wouldn't you agree?
All stadiums are different. Many of the stadiums that the sport since 1954 and Speedway occupied give multiple use for what was in the ground racing industry. There were greyhound racing venues. We've got tracks now that there is a tendency to try to move to having the freehold on them to protect them where you can afford them. The sport has drained the major stadiums because of the land value. Obviously, any business operates in a stadium has got to have a viable operating structure. And the key to moving forward with stadiums is multi-use. So there are several uses to a stadium. For example, with Coventry, Mr. Sandu invested significantly in the stadium and attempted with several planning applications to generate more revenue in it, like for example having a sports fitness centre and various other things that sadly were declined. But stadiums need more than one revenue source.
So stock car racing on its own has not been sufficient at a number of stadiums that you are aware of in order to maintain its continued viability and attractiveness to the stadium owner in circumstances where the stadium owner, they will have a number of outgoings themselves prior to, in fact, turning anything which may be either return in investment or profit, such as insurance and all of the other outgoings. That's right, isn't it?
No, that's incorrect. For example, the stadium at Stoke, at Luma Road, Chesterton, we made, on 3 occasions, an offer to buy the freehold for £1 million. When it comes to stadiums, it is rarely that the tenant becomes involved. You are basically told that your lease or licence is terminated and the stadium is sold. Even the Landlord and Tenants Act doesn't give much provision for how you can do it. In the terms of trying to save Bellevue, the fact that it was an asset of community value and a heritage value, apart from matching what the developers countrywide paid for it, so that isn't strictly true either.
Well, as far as the Landlord and Tenant Act, if it's not contracted out under the 1954 Act, then in those circumstances there would be a like entitlement to continue on, save in circumstances where there's a redevelopment provision, correct?
Correct.
Yeah. Are the leases that you undertake, or are they ordinarily within the 54 Act, or are they contracted out of the 54 Act?
Without reading the most recent ones that we had at Bellevue, I couldn't tell you.
Okay. Now, if one is to have a long-term position of viability and sustainability for a stadium, then that stadium must be capable of being, first of all, meeting its overhead running costs and meeting the costs of its future maintenance and renewal. That's right, isn't it?
Correct.
Yeah. Have you yourself been a stadium operator?
No, I've not been a stadium owner. We've always been a tenant.
So essentially, you pay an amount of rent by whatever means, whether or not it's rent so far as per event or or other costs or benefits that come from that event per event. That's effectively your rental payment, but everything else in terms of the cost of upkeep, cost of insurance of the stadium, cost of renewal, cost of maintenance, all of those things, that's paid for by the stadium owner. Is that correct?
It can vary. We pay our own insurances. But in terms of also when you rent a stadium, one of the biggest revenue benefits and one of the reasons that they stage sports like speedway and stock car racing is the biggest revenue generator which the stadium retains, not the operator or stock car promoter like myself, is the food and drink, food and beverage. That contributes substantially from the events that we put on at the stadium, and the stadium enjoys that benefit.
As far as insurance is concerned, you may carry out your own insurances in respect of an event, but it's necessary for the stadium to be insured, both in terms of public liability and other insurances, irrespective of yours, yes?
That's correct, but obviously the costs of operating the stadium, they presumably also produce a budget and amortise their costs amongst the people who are leasing it and using the stadium.
Now, in your paragraph 7, you talk about agreed heritage, prestige stadiums, heritage value. You're aware that this particular stadium at Brandon, it is not listed?
I'm aware it's not listed.
And indeed, it has not been regarded by the authority or the appellant or other public body as being a non-designated heritage asset for the purposes of national policy. You aware of that?
I can't comment on that.
Right. So you're not asserting that there is any heritage value that is recognised via the planning system in respect of the Brandon Stadium, is that correct?
Not as far as I'm aware.
Right. Thank you. Now, the Overall Racing Council is working towards recognition by Sport England. It's fair to observe it is not recognised by Sport England.
As we speak, no, but can I just add a little bit to that? I and others have been working now for 2 years with Sport England. The first major hurdle that we had to overcome with Sport England, as you may know something about the organisation, is that they will only recognise one body per sport. We have, in this case in the UK, it happens to be Motorsport UK / MSA. Therefore, we compared the same as Lewis Hamilton. We spent many hours and weeks negotiating the first stage with Sport England that they would be prepared to make an exception because there's a huge difference between oval racing and how it operates and circuit racing. So we've overcome that obstacle and we are now working through the structures and what is required for us to complete our submission for Sport England. So we are aware and working with it and understand the value of being part of Sport England.
Yeah, but Sport England have not recognised you, so you are not a recognised sport.
As such, no.
Thank you very much. In paragraph 12, you tell us about the estimate of costs. Have you looked at the structural engineer's report and the quantity surveyor's cost of construction reports that are appended to Mr. Hooper's evidence?
No, I haven't seen those.
Have you seen any structural engineer's report or costing exercise undertaken by a qualified cost consultant for the purposes of the assessment of the suggested figures that have been put forward by SCS?
I've obviously seen the figures put forward by SCS. I'm not aware there are any quantified figures for reconstruction. As far as I'm aware, nobody's been allowed access to the site to be able to do those accurately.
And have you seen any structural engineer's report?
No.
And have you been to inspect the stadium yourself?
Not in recent years. Obviously, you can't get access to it.
So far as Odsal Stadium is concerned, do you appear there as a promoter, or are you a stadium owner or operator?
Well, history with Odsal Stadium was we operated it in the late 1990s. The stadium was then supposedly going to be closed down for a period to put a roof on it, a Superdome. That actually never happened. For the next 20 plus years, we made representations to return there. Rugby League operates there. Rugby League ceased there in 2019, and we worked with the RFL to restore and return the venue to the sport in 2021. And we were a tenant with a long-term lease.
Right. Were you a participant in terms of the building works for returning that to use?
Yes.
So you actually were letting building contracts for returning it to use?
We were, our responsibility was basically installing infrastructure required for safety for operating stock car racing, and then working with the RFL in terms of restoring the buildings that were there.
So was someone else restoring those buildings?
Outside companies were contracted in to do the work. I was the principal contractor.
But were you the people who were contracting those companies to carry out that work, or was that the RFL who were doing it?
In the major works for buildings, restoring buildings, with the RFL.
Yeah. And there's no information available to us as to the comparison between the position at Odsal Stadium and this stadium. Is that correct?
Sorry, I don't understand your question.
To be able to compare the condition of Odsal Stadium prior to the works of restoration that were undertaken there and the works of restoration that will be required here. We don't have any comparison exercise.
Odsal was in a different position to Coventry. It ceased, Rugby League expired there, went into administration in September 2019. The main lease on the stadium was held by the RFL. So during that period, we started negotiations with them early 2020. The site was actually fully secured with security, etc., so there was no access to the site. So in terms of the condition of the site, in terms of vandalism and what have you, it was in a reasonably positive state. But obviously, we had expenditure in terms of putting the correct infrastructure back in, and with the RFL sort of renewing and getting it past its safety certificate requirements.
Thank you. As far as stock car racing at Odsal is concerned, what are the attendances there? Different stadium, I recognise.
I can only speak for the 2021 season because after that I retired because we'd achieved our objective. You've got to understand that we ran in a pandemic year with restricted attendances and what have you. We had an average attendance of around about 3,000. We staged a Formula One World Final there in September, but that was heavily affected by we could not have foreign competitors, foreign fans. That attracted 7,000 people in the restricted pandemic environment.
Thank you. You tell us in paragraph 14 that Brisker F1 attracts audiences that generally cover running costs. Whose running costs? Yours as promoter?
Yes, as the operator of the events.
Now, in terms of those costs, revenues, numbers of attendees, participants, and what they spend, do we have any data on that?
I don't have any to hand.
Thank you. You tell us at paragraph 13 that stock car racing has had the support of significant companies and businesses. Can you place a numerical figure upon what has been provided and by whom?
Sorry, which document is
It's
this?
your statement.
I haven't got that one in front of me. Could you just read it?
Yeah, surely. That's all right. Stock car racing has the support of significant companies and businesses that can deliver the necessary works and expertise required, as shown by our own Odsal experience, where tremendous support was forthcoming from fans and associated businesses in the innovative commercial models we deployed. Is there anything in terms of who the companies were and what they provided?
Not that I can give you today in written form, but we are a community sport, very similar to how Coventry have identified. Much of it is available online for evidence. We did various things that involve the community, from GoFundMe to individual companies stepping in to sponsor some of the remedial works that were required within the stadium. We are a community sport with many people that participate or spectate in it, that have a huge love for the sport and will step in to assist.
No, that's why I was asking about the significant companies and businesses that were referred to and who they were, because obviously if they were significant companies and businesses, then the extent of their identified involvement might be more notable than simply a whip round.
Well, one of them was Mitten Group, a big national company who supported us and the Bradford Bulls.
Right, and can you tell us how much they supported?
I can't in front of me now.
Right.
Does that indicate what they actually supported in terms of physical works on the ground?
They supported Bradford Bulls ourselves, infrastructure work, electrical work, certification, things like Legionnaire, checking a full suite of services.
Now, your letter that was attached to your statement, this is a letter dated the 28th of July 2023 that says that there have been inaccurate misrepresentations by those acting on behalf of the appellant. Which representations and by whom do you say have been, what representations do you say are inaccurate and constitute misrepresentations?
I believe, from my opinion, and things I've heard last week, a lot of the things that
No, this is 28th of July, so it wouldn't have been about last
it was
week.
backed up by things that have already been said around the table in the last week.
Yeah.
There's been representations about how the sport has shrunk in size, asserting that it is no longer a viable sport. Those are the main points of conjecture that I would say they are wholly inaccurately. The sport has had to change. It has had to adapt to change, particularly by the number of stadiums over the years it has lost for redevelopment. But it is not a basket case sport, as seems to be sort of the picture is being created. It is a vibrant sport. That, as I say, we have to evolve as circumstances evolve.
Yeah. Thank you very much indeed, Mr. Rees.
Right, okay, thank you, Mr. Goatley. And thank you to you, Mr. Rees. I have no further questions. Mr. Goatley's covered some of the things I was going to ask. So thank you very much for attending this morning. It's been very helpful. So, the next thing on our agenda this morning is to have Mr. Hooper, who is the appellant's planning witness. So we'll just have a short 10-minute break, I think, just to enable everyone to reorganise themselves and sort out papers. So we'll have a quick break then until 5 to 11. Thank you. Right, thank you very much, everybody. We are now on 5 to 11. So we're going to continue now hearing from Mr. Hooper. So, Mr. Goatley, would you like to introduce your witness, please?
Thank you very much indeed. If I can introduce Mr. Hooper to the witness stand. You're Gareth Hooper. You have a Bachelor of Science Honours degree in Geography from the University of Exeter and a Master of Science Distinction degree in City and Regional Planning from Cardiff University.
I do.
You're a member of the Royal Town Planning Institute and you have over 22 years of professional experience in the field of town and country planning, during which time you have provided advice on the delivery of planning strategies on a wide variety of public and private sector jobs and instructions across England and Wales.
I have.
In November 2014, you were made the Chief Executive Officer at DPP Planning, a national award-winning town planning consultancy, and in that role you've supported numerous complex planning proposals throughout the UK, ranging from urban extensions to new and improved sporting stadia.
I have.
Indeed, you set out in September 2020, you secured permission for the erection of 360 dwellings at the former cattle market site at Craven Road in Rugby, and you're currently engaged on 2 further speedway sites, advising on possible alternative uses for those sites, and you've been engaging in pre-application dialogue with the relevant local planning authorities, and you're engaged in relation to the efforts to find a suitable site for a multi-motorsport arena in the Swindon area.
I am.
You set out your instruction from Brandon Estates since June of 2021, having taken over from the previous planning agent, and you set out on page 4 of your evidence your attestation that the evidence you give to this inquiry is true, prepared and given in accordance with the guidance of your professional institution, and that the opinions expressed are your true and professional opinions.
Yes, that's correct.
Thank you very much. Now, Mr. Hooper, you have provided a proof of evidence together with appendices, and those appendices comprise a number of elements. I'm not going to go through each and every one of them, but I would observe that Appendix 1 has a chronology of Brandon Estates' involvement in the site. Who produced that chronology?
The appellant.
You also provide a schedule of speedway riders and nationalities. Who provided that to you?
We took that directly from the Speedway website.
Thank you very much. A structural condition report from Farrow Walsh Consulting and a cost report by rider Levitt Bucknell, together with a full report from the council in respect of the Bellevue Stadium, Manchester, which is your Appendix 5. You also have the council's records of noise and dust complaints. That's Appendix 6, and that's referable to the site?
It is, yes.
Thank you very much. You then have appendices relating to the planning notices at Bellevue and the replacement stadium at Swindon, and other relevant features relating to this site, Appendix 9 and 10. Appendix 11 is an economic benefits assumptions note by Litchfield. 12 is a schedule of representations by others, and 13 are the home address of interested parties as mapped at the national scale, and 14 is those similarly focused on the local scale.
Yes.
Thank you very much. Mr. Hooper, with respect, I'm going to, and Mum, with your permission, I wasn't otherwise going to ask Mr. Hooper to go through any of his proof of evidence or to read any of it, but I was going to go through some of the subject areas that have principally been engaged during the course of this appeal in order to ask his views on it.
That's absolutely fine. I'm happy with that. Thank you, Mr. Goatley.
And thank you very much indeed. Principle of development first, if we may. Actually, before I deal with that, just to make sure I don't forget it, because having trailed it earlier, the evidence in respect of the distances to the Brandon pitch, which was promised during the end of last week. Are you able to assist us with that material?
I am.
And if you can set out what you have been informed and what, if anything, that tells us.
Yes, I have received a detailed note from John Eady at KKP outlining the distances and drive times of the clubs that were outlined in his evidence. Those relate to large clubs with 5 teams plus, identified by the BCFA with an approximate 5-mile radius of Brandon Stadium. So I have a list of clubs and distances and drive times associated with those. So I'm quite happy to read those out, if appropriate.
Just 2 in particular that we were checking over, St Finbarrs and Mount somewhere, I can't remember. That's in Mount Nod, I think it was those 2 in particular.
So St Finbarrs FC, the distance from the site is 4.9 miles, and the approximate drive time is 15 minutes. And Mount Nod FC is 7.4 miles and approximate 20-minute drive time.
If it would assist, we've got a fuller list, and so we'll get that printed out and provide that to you tomorrow.
Fine, that's helpful, thank you very much.
So far as that 20-minute approximate drive time, has that been the subject of identification as to what, if anything, that has significance for, if at all, for these purposes?
Yes, that is consistent with the Sport England guidance in ANOG. It is also consistent with the Football Foundation, which works to a 20-minute catchment, and in particular the Park Life documentation.
Thank you very much. So, returning to your evidence proper, principle of development. First of all, matter not in contest with the local authority, but with SCS. Is this inappropriate development?
No, in our view, it is clearly not inappropriate development, as agreed by Mr. Stevens yesterday, and at the application stage, the appeal proposals do not form inappropriate development.
So far as the site, the subject of this form of development, is it previously developed land?
Yes, again, as accepted yesterday by Mr. Stevens and by the LPA at the application stage, the site in totality represents previously developed land.
Thank you very much. Now, next point is in terms of effective and efficient use of land, albeit 2 distinct features. What, if anything, do you say about the public interest in effective and efficient use of land? And what, if anything, is the significance of the appeal proposal in context of that?
Yes, drawing on MPPF paragraph 119 that was referenced yesterday by Mr. Stevens, the proposals are consistent with the intentions of that paragraph, making an effective use of the derrick site to meet the needs of homes whilst improving the environment. The proposals represent significant improvements to the environment regarding the condition of the site, promoting BNG, creating open spaces.
Now, so far as the provisions of 119 were concerned, there appeared to be at least some query as to whether or not 119 was happily engaged in that regard. Your view, it is happily engaged?
Yes, it is engaged in our view.
Moving on and beyond that, I'll come back to the issue of BNG, if I may do, in due course. Whether or not it's suitable brownfield land in context of paragraph 120 of the NPPF, your view in that regard, please.
Yes, clearly the site is brownfield land in relation to paragraph 120. Obviously, we acknowledge that we are not located within the settlement boundary, but there is still a benefit in the site coming forward on a brownfield site.
Now, Mr. Stevens said yesterday that he would accord the use of that land as proposed by the appeal proposal as significant rather than substantial weight. Do you have a different or a similar view to that?
I think, referencing paragraph 120, the reference to being located within the settlement boundary and the significance of weight does have a bearing on our site. And therefore, I think we accept that significant rather than substantial weight should be afforded to the appeal proposals. That significant rather than substantial weight should be afforded to it in that context.
In terms of that which is proposed, will it support an appropriate opportunity to remediate despoiled, degraded, derelict, contaminated or unstable land?
It will.
Thank you very much. Now, Mr. Richards, in his questioning of Mr. Stevens, posed the question about, well, what happens if the appeal is dismissed? Where might that lead to? Mr. Stevens first sought to advance that there would be no prospect, as currently identified, of compulsory acquisition by the council, but essentially a hope, if not an anticipation, that the landowner would wish to dispose of the site in order to deal with, among other things, the costs of maintaining security and the like around the site. What would be your view as to the position of the landowner in these circumstances, and what would you expect to occur if that were to take place?
Yes, as discussed yesterday, the landowner is clearly under no obligation to sell the site. There was a reference yesterday to the site costing the appellant money. I can confirm the appellant owns the site outright, so there is no financial costs associated with it. There would be ongoing security costs, so we do accept that. But in the context of the opportunity that lies with the site, it is clear that the appellant would not simply disappear. There is no prospect that they would look to sell the site, and therefore it is a realistic prospect that the status quo, as it was referred to yesterday, would be the position of the site.
Now, it was, I think, suggested that a failure to sell the site in those circumstances would amount to some form of blackmail. Your view in respect of that contention?
I think that is clearly without foundation. The appellants have submitted a planning application. It went through a due process, a very long process with the local planning authority, with a recommendation for approval. The application was then rejected. There is no form of blackmail here. This is a normal planning process that we're engaged with. Suggestion that rejection of the appeal proposals will be good for sport. I reject that as well. We will come on to evidence in relation to the need of the proposal and the benefits that result from it. So I suggest that blackmail is completely inappropriate in this circumstance.
Just as an observation, we'll doubtless will come back to the provision of the 3G pitch. But what do you make of the chronology that I explored with Mr. Stevens and indeed Mr. Allen before, of a playing pitch strategy from 2015, a local plan from 2019, which attest to a need for at least one sports pitch, Mr. Eadie's evidence saying that there's a need for rather more than that now, and a failure to provide at least even one sports pitch as identified over that intervening 8-year period.
I think, as became apparent yesterday, consistent failure since 2015 to deliver any sports provision, and the suggestion that the strategy should be to wait for the local plan to be delivering those solutions, or indeed wait for Section 106 contributions to be delivering those. Clearly, the track record is such that that hasn't delivered results to date. The prospect on the table is a privately funded and delivered 3G pitch, of which it is common that there is common ground that there is an identified need.
So far as housing is concerned, two aspects to the housing, particularly. One is market housing, and secondly, affordable housing. So far as the market housing is concerned, no issue in play that the council is currently able to provide a 5-year housing land supply.
No.
Your views, please, as to what, if anything, constitutes the benefit referable to the market housing, first of all, and what, if anything, when it comes to the planning balance, should be the weight applied to that?
Yes, as you say, no contention that the council is not able to demonstrate their 5-year housing land supply. However, that is not a maximum figure. We heard evidence yesterday regarding the housing crisis. There is an identified need for housing. There is a national imperative to encourage development of housing, particularly on brownfield sites, and therefore we present that the delivery of 98 market houses at the appeal site does constitute, in our view, moderate weight.
And that's moderate weight beneficial?
Yes, it is a benefit relating to the planning application, the appeal.
Thank you very much. So far as the affordable housing is concerned, I know that Mr. Stacey has already expressed certain views with regard to affordable housing. What, if anything, do you say with regard to the affordable housing?
Yes, as having sat through that session yesterday, it is clear that there is an identified need. As Mr. Stacey outlined yesterday, there is a national housing crisis, and therefore the contribution that this site is making to the delivery of affordable housing is a significant, substantial benefit associated with this appeal proposal.
And what weight would you attribute to that?
We apportion substantial weight.
Now, a subsidiary issue that Mr. Stacey dealt with during the course of his evidence, and indeed during the course of the roundtable session, was the housing mix. Is there anything that you need to add to that which has already been said in context of that, or anything that you'd like to highlight?
Yes, obviously Mr. Stacey's evidence principally related to the affordable housing, so that there were comments made in relation to the mix of that, but also the market housing. We acknowledge that policy H1 in relation to the mix suggests that the latest SHMA is the starting point for the appropriate mix. It does make provision for flexibility within it. It is on a district-wide basis that mix is proposed, and therefore, in our view, it is a planning judgment that the mix, which is not in line with the indicative mix provided in policy H1, is appropriate, and that mix has been agreed as common ground with the LPA.
Thank you very much. Now, I referred a little earlier when I was going through your appendices to the economic benefits, which are set out in Appendix 11 to your evidence. As far as you're aware, you may just wish to bring that up if you would, have that available to you.
Yes, I've got it.
Now, Appendix 11 comprises two things. First of all, what is now charmingly conventionally described as an infographic, which is a single page which sets out many of the salient components together with a number of fetching pieces of diagrammatic coloration, but that is drawn from the note that then follows.
That's correct.
So far as those economic benefits are concerned, are those matters which are in contention, so far as you understand?
No, there has been no counter-argument put to us.
And what would you say about those as far as they weigh within the planning balance?
I think given the significance of the job creation, the financial benefits that will arise from the proposals, we believe that substantial weight should be afforded to those economic benefits.
Thank you very much. Turn, if we may, to the...
Mr. Gerthy, before we continue, I just have a slight problem with whether you're referring to significant or substantial weight, because in your evidence at times you say significant, yet this morning you're saying substantial.
Yes.
So I just wanted to understand, is there a difference that you're referring to, or what exactly is your position in terms of weight?
In terms of the maximum weight that we believe could be afforded is substantial. So,
Places in your evidence you're suggesting significant weight for economic benefit, yet this morning you're saying substantial.
yeah, apology, that's an inconsistency in terms of the terminology that's used.
Yeah, I just want to be clear what your evidence is.
Yeah, the conclusions in my final pages of my proof set out the summary of our assessment of weight that's afforded.
Okay, all right, thank you.
If we might look, please, at the planning policy, starting off, if we may, with the local plan, which is CD 8.2. Going to go, first of all, if I may, in context of that, to HS4, that being the policy referred to on the decision notice. And it is HS4C. Thank you very much.
Yes, I have that.
Thank you very much. Now, a matter explored with Mr. Stevens yesterday, so far as Part C of that policy is concerned, that is the part of the policy with which conflict is asserted by the local planning authority. Is that same as or different to that which is in paragraph 99 of the current version of the NPPF?
It is the same.
So when one's dealing with a consideration of those relevant tests, same points arise, and so far as the relevant criteria, here, the first, second and third bullet points, are they conjunctive, i.e. they all need to be satisfied, or disjunctive, such that only one is needing to be satisfied?
They are disjunctive.
And so far as your evidence is concerned, do you contend that one or more of those is satisfied, engaged and satisfied by the appeal proposals?
Consistent with our approach on paragraph 99, we believe the first and the third elements of the policy are satisfied.
Thank you. Now, I'm going to come back to that in context of paragraph 99, so as not to repeat that, if we may. There was also reference, you may recall, from Mr. Carter albeit he stepped back from it when we had the opportunity to discuss it, as to the engagement and application of policy HS3 relating to protection and provision of local shops, community facilities and services. In your view, is that engaged and does it apply in this instance?
No, it doesn't apply in this instance. The site is not defined as falling within the criteria that policy HS3 relates to.
Thank you very much. Is there anything else within the local plan that you consider to be of relevance for the purposes of the inspector's deliberations?
No, I think taking the plan as a whole, it is clear that the drivers for the local plan are about providing housing and facilities to meet the needs of the resident population, existing and future, and we believe that the appeal proposals are consistent with that overarching objective.
Thank you very much. If I can ask you then to take up the neighbourhood plan, which is CD 8.3, and I'm going to particularly take you to page 44, which fortunately is also PDF page 44, which is policy LF1.
I have that.
In context of this policy, text set out, please read it to yourself as appropriate. Essentially, first aspect, looking for the retention, enhancement or improvement of valued community facilities will be supported. If the relocation of a facility is involved, the new location will be equally well located for the community it serves. Are we dealing with a relocation here?
No, we're not.
Proposals that would diminish or remove a community facility will be required to demonstrate the facility is no longer needed or viable, and that there is no realistic prospect of viability being improved with either the current or other community uses. New community facilities will in principle be supported. Dealing with the components of that, the removal of a community facility, and this is the removal of a community facility because it's expressed such in the last paragraph
Yes.
of Brandon Stadium presently closed. The requirement to demonstrate the facility is no longer needed or viable, and there is no realistic prospect of viability being improved with either current or other community uses. Assist and unpack that, please, as to whether or not that is engaged, and in respect of the elements engaged, how, if at all, it is satisfied.
Yes, we believe those elements are engaged. As the local plan requires, the need associated with the site, albeit in the context of LF1, relates to a community use rather than a sporting use. Fundamentally, the case that is presented is regarding that community use being predicated on speedway and stock car racing returning at the site. We have presented evidence on the fact that there is no need for those uses to be presented. We have had no alternative community uses being presented, at least initially in the jumpers for goalposts scenario that has been outlined as the starting point. And therefore, we believe that there is no longer a need for this community facility in this location. In relation to the second element, the viability, that need and viability we will come on to. Our belief is that viability is intrinsically linked to need, and therefore the submissions that have been made and the evidence that is before this inquiry demonstrates that there is no viable prospect of that site coming forward. And even in the jumpers for goalposts scenario that has been outlined by Save Coventry Speedway, we do not believe that that is a viable prospect.
Going to come back to some elements relating to the policy, but just if I may divert for the moment, the jumpers for goalposts suggested option, how appropriate in your view is that for the purposes of the proposed reinstatement in the manner currently suggested by SCS?
As the inquiry has heard, the basis, the financial basis that is before this inquiry in terms of the costing and the works that have been undertaken have not been qualified through appropriate structural or cost consultants. It is also evident there has been no health and safety assessment of those proposals, and those who have attended the site and have seen the evidence that is before it in terms of the structural survey, we raise significant concerns about the jumpers for goalposts scenario that doesn't seem to have any provision within it in relation to insurances or health and safety measures.
Thank you very much. Now I'm going to at the moment just jump to the last sentence at the moment, but I want to come back to the other components within that first paragraph of LF1 in a moment. But as far as the last sentence within the first paragraph, new community facilities will in principle be supported. Mr. Stevens' view was that with regard to the 3G pitch, that accorded with that. Your view, please?
Yes, what we are proposing is consistent with the final paragraph of LF1.
So far as the components, and it may well be that not very much turns on it, but is this a sequential policy in its terms, i.e. you do one first of all, if you don't do one then you do two, and if you don't do two you then do three?
No, I don't believe that to be the case. If that were the case, I believe it would be explicit within the policy or within the supporting explanation. It is not. As you alluded to yesterday, reading it in order is one thing, but that in itself does not require a sequential approach.
Taking the development plan, please, as a whole, both the local plan and the neighbourhood plan, your view, please, as to whether or not there is conformity or conflict, read as a whole.
Read as a whole, we believe it is in conformity.
Now, if we may go to the NPPF, which I think is CD 8.1, and want to have a look specifically at the elements relating to paragraph 99.
Yes, I have that.
Now, 99 is located within Section 8 of the NPPF under the heading of promoting healthy and safe communities. In respect of components there, and as far as 99C, so I beg your pardon, 92C, first of all, a matter which was raised during the course of yesterday. How, if anything, do you say that that aspect of policy relates to the consideration of the appeal proposal?
I believe it can be applied directly to the appeal proposals. It is supporting healthy lifestyles, that is promoting the provision of green infrastructure, the provision of sports facilities. There is no reference to stadia, and therefore it is reasonable to judge with good sense and realism that the paragraph is talking about the form of development that is before this inquiry.
Thank you very much. If we might next move to paragraph 98, dealing with open space and recreation. The contention was made that this paragraph, and indeed policy, relates to stadia as well, on the basis that that's where people congregate within some kind of generalized sporting context, and that their health and well-being, particularly their mental health, is supported by means of that process, and that therefore a stadium comes within paragraph 98. Your view, please, as to that.
I disagree. Spectating is not directly referenced, and it's with good sense and realism that we say that this paragraph follows that in 98, and it is intended to relate to the participation rather than spectating. Ultimately, that is a matter of planning judgment, and that is a difference between the parties, but we believe that our view is fair and is reasonable in interpreting that paragraph.
Something into paragraph 99, about which we've already referred and the inquiry is already dealt with. You have already explained the direct parallels between this and HS 4C of the local plan. Existing open space, sports and recreational buildings and land, including playing fields, should not be built on unless, and then A, B and C, which of those are engaged, which of those apply to the consideration here as far as the case being advanced?
Criterion A and C.
So going to A, first of all, an assessment has been undertaken which has clearly shown the open space buildings or land to be surplus to requirements. Some measure of discussion and debate as to how you assess surplus to requirements. Your view, how has that issue of surplus to requirements been addressed by the application, and what components fall within the process for consideration?
The evidence before this inquiry represents an assessment of whether the site is surplus to requirements. The evidence presented by KKP and the proof of evidence of John Eadie clearly sets out an assessment of the health of speedway and stock car racing to seek to demonstrate clearly that the site is surplus to requirements. The information set out in those assessments is based on the information that is available to us and is available publicly. There has been criticism of the extent of that evidence, but nobody that has appeared before this inquiry or has presented any other information has been able to present any information contrary or in addition to that which is presented.
Your view, please, is that paragraph not only engaged, is it complied with?
It is engaged and complied with.
Looking, please, at the next paragraph, the next relevant paragraph being criterion C, you've already indicated it is only necessary to conform with one of those two in order to be in compliance with that policy. Development is for alternative sports and recreational provision, the benefits of which clearly outweigh the loss of the current or former use. Is it engaged? Does it apply?
It is engaged and as consistent with the view of Mr. Stevens yesterday.
As far as the issue of viability is concerned, first of all, does viability fall within any of these criteria, or is it a freestanding component?
Viability is intrinsically linked to the demonstration or the test in relation to whether this site is surplus to requirements. The evidence that is before the inquiry has looked at participation levels and the spectator levels as a driver for demonstrating that this site is no longer required and is therefore surplus to requirements.
Now, it appeared that so far as reliance on evidence, the Council was looking to the Rule 6 party SCS. What, if anything, has SCS been able to assist us as to either speedway riders or participants in stock car racing, and whether any such of those participants are unable to undertake their sport by reason of the closure of Brandon?
Mr. Carter includes in his evidence, CD 1016, paragraph 5.13, a single year participation figures for Brandon Stadium, which I think he outlined yesterday. That is the only figure that is before this inquiry in terms of participation. In terms of spectator numbers, we've heard lots of suggestions around different figures of spectators. There is no definitive historic evidence of spectator numbers, and therefore the impact of the closure on those spectator numbers has not been possible to assess. In relation to the impact of the closure on participation, as we heard yesterday, Mr. Carter outlined 2 stock car drivers that he was aware had given up the sport as a result of the closure of the Coventry Stadium. He was not aware of any any speedway riders that had given up the sport. Indeed, he referred to speedway riders as being footloose.
And as far as Mr. Rees this morning, who's been able to assist, so far as stock car races are concerned, what appears to be the likely distance that they travel for the purposes of exercising their sport?
As Mr. Rees confirms, they are willing to travel significant distances. Critical to the assessment of the need and the surplus requirements is that there are no geographical spatial requirements in relation to motorsport. It has been demonstrated stock car and speedway competitors and spectators will travel distances to engage in their sport.
So far as the issue of financial realism of any reinstatement proposition, do the Council consider that is irrelevant to the purposes of the deliberations before this inquiry?
They appear to, yes.
But financial realism?
Financial realism doesn't appear to be a key factor in their case. Our view is that there is a fundamental requirement for this to be a realistic assessment of the site in its current form and the requirements for reinstatement, and also the long-term future of activity at this site, even if it were reinstated. We have seen no business plan to take forward the ongoing operation and future of this site. Indeed, we haven't seen a business plan in relation to speedway or stock car racing on a national level.
Now, it's not been a key part of their case. I'm not sure whether you were here throughout Mr. Stevens' evidence yesterday as to how he thought the issue of financial realism ought to be addressed, whether within policy or out with policy.
Mr. Stevens considered it to be out with of policy. We believe that it is a fundamental consideration of the policies that are before this inquiry.
Now, the alternative sports provision, just in terms of numbers, we heard from Mr. Eady, and Mr. Allen confirmed that broadly of the order of 1,200 persons per week, and then looking at a build-up, looking at approximately about 50,000 a year, without wishing to be overly exact in terms of use. It's contended by the Council and SCS that, yes, this is not football or whatever other sports may be played on the 3G pitch, but that their sport has a need too. How would you say that the inspector would assess those different numerical aspects, both in terms of participation and to the extent that it's contended spectating for the purposes of the approach to paragraph 99 of the NPPF?
Yes, clearly it is not our contention that this is just a numbers game. But clearly, if we are looking at numbers, and that is something that has been put to us, there is a significant difference between the speedway stock car use, as set out by Mr. Carter yesterday in relation to the 2016 season, of 170 speedway riders, 765 stock car drivers who took part in events that year, versus the evidence of John Eady, which, as you say, indicates 1,200 participants per week, and on the basis of a 36-week use throughout the year, would equate to 40 to 50,000 participants each year, some 98% more usage than the speedway.
Now, also within paragraph 99 and criterion C, Mr. Stevens sought to contend that in that regard, the proposal was, in one sense, for a residential development to which there's a sports pitch, and that on that basis, paragraph 99C is not engaged. Your view, please, as to whether that is a correct interpretation and application of that policy.
I disagree. It is firmly engaged, and I think Mr. Stevens did actually accept that the paragraph is engaged. Mr. Stevens' analogy of it being on a spectrum, we do not accept. It is clear that 99C doesn't use the words exclusive, solely, predominantly, and therefore it's reasonable and straightforward to interpret that 99C can be applied in this instance.
Now, we've looked at some of the aspects relating to pitch need. I'm not going to go back to that. There was a suggestion, one which was to a degree also pursued with Mr. Eady, that somehow this wasn't the best site, and that there were other priorities. Now, that was the subject of cross-examination, and Mr. Stevens' answers to that are doubtless before the inspector. As to that, is there any policy or other requirement for a best site or some beauty parade?
No, there is none at all.
In any event, how many candidates are in the beauty parade?
It has been confirmed there are none beyond this site.
From the material which you have seen, including the various travel and location distances, is there anything to indicate that this is out of accord with Sport England guidance for the location of such facilities?
No, as set out in the evidence of KKP and of John Eady, this is an appropriate location to meet the identified need.
Prospects of the 3G pitch going bust. That seemed to be a recurrent theme. One, is there any evidence of likelihood that you've seen?
None at all. The starting point for the assessment of that is that the There is a business plan that underpins the suggested pitch provision that has been undertaken by KKP, one of the UK's most experienced sports provision consultants. That business plan demonstrates that whilst there would be an initial loss in the start-up years, it would move to a profitable position. As such, there is no suggestion, and we've seen nothing to the contrary to suggest that there is a threat posed to this pitch.
I asked Mr. Allen and Mr. Eadie in that regard to identify any instances where that's occurred, and neither of them were able to identify any such instances where it has occurred. Just to take the counterfactual, are there any mechanisms in place in terms of the suggested processes for provision of this particular pitch that would secure that pitch in the long term, even in the circumstances being contended for?
Yes, as I say, the starting point is that there is a robust business plan behind the pitch, so we are setting out on the best possible scenario for this being a success. However, at the local authority's request, a clause has been inserted into the draft Section 106 agreement, enabling the transfer of that pitch upon completion. So that is before this inquiry that the authority could take that pitch upon completion. Mr. Eadie referred to a dowry payment, in effect a payment that sits on accounts that can be drawn into the operation of the pitch and the pavilion in the need that it needs financial assistance. An amended Section 106 with amended text has been presented to the planning authority to consider that with a figure associated with that. And thirdly, we have also suggested that there is a step-in clause inserted that in the event of a failure through a private entity taking the site forward, the local authority could step in and take the pitch at a later date. And therefore, we believe that there is a very thorough belt and braces approach to this pitch.
Thank you very much. Now, in terms of some of the matters relating to the issue of viability, if I may return to that, in terms of understanding where we are at and what is said. First point, viability of Speedway itself. Is it in rude good health, as Mr. Carter and others might seek to contend?
The evidence comprising both factual and relevant personal experience from Mr. Clark Osborne, who will be giving evidence tomorrow, demonstrates that unfortunately Speedway is not in rude health. There is a trend of reducing teams. There is a trend of falling spectator numbers. There appears to be a trend historically of falling television numbers, which in our view demonstrates to a decline rather than any uptake in the sport.
And is that in respect of both participants and spectators? What information do you have?
It is in relation to spectators. We're not aware of any published spectator information. Obviously, Mr. Carter alluded to the 2016 season at Brandon, and we heard this morning about Aldsall Stadium, but there is no definitive evidence before this inquiry on spectator numbers for whatever reason. In relation to participation, the evidence of KKP has demonstrated the number of teams and therefore participants has declined. I think it is a fair comment that the reference to teams going bust is a little unfair. It is simply that those teams no longer operate. I appreciate there is a difference between going bust and not operating. But the fact is those teams, the number of teams who are operating, who are competing, has declined over a period of time.
Cost of operation of the Speedway tracks. I so far as the evidence we've heard hitherto has not come from those who are site operators as opposed to those who are promoters.
No, that's true. The evidence from Mr. Clark Osborne, who is a stadium operator, provides a clinical insight into the costs and the challenges of operating a stadium.
What about those costs? Are those costs, so far as you understand it, stable, reducing, increasing?
I think as we've heard throughout the inquiry, there's been an acknowledgement by all parties that costs in life generally are increasing. So you add energy as a key criteria, lighting of stadia, but in addition to that, increasing regulation that has taken place in relation to general events and in relation to noise and other elements that a speedway stock car operation would be subject to, means that they are subject to significant and increasing costs year on year.
Thank you very much. Prospects of other means of control. Now, one issue that has figured from time to time is it would be necessary for there to be any planning permissions going forward for the resumption of the site. Would there?
Yes, my proof of evidence refers to scenarios that we examined in the context of what we believe would need to be delivered to achieve a viable long-term future at this site. The starting point for that, based on the structural survey that's been submitted, is the demolition of the grandstand and significant works to the site that, in our view, constitutes development and therefore would be requiring planning consent.
If it did require planning consent, what, if anything, would you anticipate would be the outcome of that?
The outcome, as illustrated by the examples that are accompanied in my proof of evidence in relation to Swindon and in relation to Bellevue, I believe that it would be subject to a number of restrictions in relation to its operation, not least in relation to noise and times of operation.
So far as demand for Speedway, costs, and how those issues of profit and loss are identified and are set out within the evidence before the inquiry, does that show that Speedway has a happy and profitable future?
No. If you look at the profit and loss accounts that Mr. Rob Osborne has submitted to this inquiry, it is clear that with an annual operating cost of Speedway of £845,000, the resultant profit would be £3,609 per annum.
And that's CD 15.5.57.
That's correct. I think a fundamental point that should not be forgotten is the actual purchase of this site. This site is not in the ownership of anybody who is currently intending to bring this site forward as a new or a jumpers for goalposts scenario.
Now, the costs of reinstatement of the stadium, we have that which is set out within Appendix 4 of your evidence, the cost report by Ryder Levitt Bucknell. We also have some cost estimates that have been put forward pardon me, by SCS in terms of a variety of items, though not all of the items that are referred to in the RLB cost report. Where do you say that takes us in terms of the comparability? Is it just a case of slightly cutting down the number of items that might be necessary and thereby increasing the viability of a mechanism of return?
Yes, we've heard a lot about SCS's intention for the jumpers for goalposts scenario that is being presented and the cost estimates that have been presented to this inquiry. We've had confirmation from Mr. Carter that those are estimates. They haven't been qualified by a structural engineer or a cost consultant. By contrast, the cost estimate that is included within my evidence by Riley Levitt Bucknell is based on an assessment of what we believe, based on the information available to us and the Stadia experience of Mr. Clark Osborne, would be required to make Brandon Stadium viable in a full sense. So effectively, the end game. The proposition that's made is that we haven't compared the RLB figure, which is into the millions, versus the SCS estimate. The evidence that is before us, so looking at the cost estimate that has been presented by, Mr. Hunter, which is CD 16.2.4, it is very easy to look at a comparison of key items which would be common to both the jumpers and goalposts and our assessment. I've identified in those two documents 5 key ticket items which both parties are including within their cost estimates. Making good perimeter fence, clearing site of loose material, asbestos and disposal, restoring terracing on 3 sides, reprovision of electrical supply and reinstatement of water supply. Those items, when totalled, in the SCS cost estimate, comes to a total of £332,000. In the RLB qualified cost estimate, it comes to £942,000. So simply taking those items which are common to both scenarios.
So just as I've got those figures, so we've got those. So in terms of your 5 ticket items that you referred to, the identified evaluation of those on behalf of SCS is how much?
So running through those in turn, make good perimeter fence, SCS is £2,000. Our RLB qualified assessment is £242. This is, for reference, it's CD 16.3.1, Appendix 4. I can give you the lines that these relate to as well as I go through. Okay. So SCS, make good perimeter fence, £2,000. RLB cost estimate, £242,000, £242,750,000. Those are lines 8.4.1 to 8.4.3 in the RLB estimate. Item 2, clear site of loose material, asbestos and dispose. In the SCS estimate, that is £10,000. In the RLB estimate, that is £100,000. And those are lines 0.1.1 and 0.1.2. Item 3, restoring terracing on 3 sides. The SCS estimate is £5,000. Our estimate, or our RLB's estimate, I should say, is £100,000. That is line 7.1.2. Reprovision of electrical supply, SCS is £300,000. The RLB estimate is £400,000. Those are lines 5.8.1 and 5.8.3. And finally, reinstatement of water supply. The SCS estimate is £15,000. The RLB estimate at line 5.4.1 is £100,000. I would emphasise those are just 5 items that I've taken which are easily identifiable across both proposals. We could carry on with those other elements. It is correct, and it has been pointed out, that a significant amount of the RLB cost that is in the cost plan that has been presented to this inquiry is in relation to the grandstand, reprovision of that grandstand. Our intention in doing that is about the experience from stadia operators about how you make a stadium viable. And that viability is largely predicated, as we heard this morning, on things like food and beverage and facilities. And therefore, that's why we contend that the long-term future of this stadium would need to look at the cost estimate that is presented by RLB.
Going back to the terracing, did you say 7.1.2?
7.1.2.
Okay.
Now, before going to weight-related issues and those features, perhaps we can just go back to the main issues point as identified by the inspector, and where we say signposting this. Firstly, whether the proposed development forms inappropriate development in the green belt and effect on openness and green belt purposes.
No.
Your view, please?
No, this is not inappropriate development.
Effect on openness and greenbelt purposes?
As presented by Mr. Chard, the effect of openness in the green belt is limited.
Is there offence to greenbelt purposes?
No.
Second point, whether the stadium is surplus to requirements having regard to national and local planning policies.
Yes, we believe we have demonstrated that the stadium is surplus to requirements based on all the available information that's before us, and now no contrary information has been presented that we could have relied upon.
Thirdly, whether it is financially viable to reinstate the Speedway Stadium.
We have presented evidence to demonstrate it is not financially viable to reinstate the stadium.
4, whether there's an identified need for alternative sports provision proposed.
It has been accepted that it was an identified need.
Whether the benefits of the alternative sports provision outweigh the loss of the former Speedway use.
We have demonstrated that the benefits do outweigh.
Can I just ask one point in that regard? Mr. Stevens was suggesting that because this is relatively a small area within the district, that in actual fact it really doesn't really figure. Your view?
I think that's a surprising comment. The sites at a district level, yes, it is part of a bigger picture, but clearly the local plan strategy, national guidance is in seeking a cumulative benefit through sites coming forward that deliver the benefits as set out in the local plan and in the NPPF.
5, whether the benefits of the alternative sports provision outweigh the loss of the former Speedway use.
We believe, both in terms of the benefit to the community and the community use agreement that would be in place on this pitch, in terms of participants, in terms of numbers, and the fact that there is a track record of failure to deliver identified need for sports pitches, mean that there is a significant benefit in this site coming forward for that use.
Other benefits of the proposal, including delivery of new market and affordable housing.
Yes, we accept that the council is able to demonstrate that it can meet its housing land supply. That should not count against this proposal. It is making a contribution towards meeting the housing needs of the community and the future needs of the community. It is on a brownfield, previously developed site, which will relieve pressure on greenfield sites in the future.
Whether the proposed development makes an appropriate contribution to education.
Yes, that is not a matter of difference between the parties now.
Coming to the overall planning balance We've looked at the weight for certain elements. If we can just, in the light of the previous exchange, just be clear, so far as the pitch is concerned, what weight do you attribute to that?
Substantial.
For the market housing,
Is significant.
affordable housing,
Is substantial.
Right, can I just, maybe my recollection, but in terms of market housing, did you not say was moderate weight in your presentation rather than significant?
Apologies if I did, that was an error.
Or can we be clear, because it is important?
Yeah, significant.
Significant,
conclusion,
not
yes.
moderate weight to market
Is
housing.
significant to market
Significant,
housing. Yes.
right, okay, thank you.
economic benefits,
Substantial.
environmental benefits,
Substantial.
anything else you would like to deal with at this stage, Mr. Hooper?
No.
Thank you very much.
Right, thank you very much, Mr. Goatley. Mr. Hooper, so, Mr. Richards, would you like to start your cross-examination, please?
I would. Mr. Hooper,
Good afternoon, Mr. Richards.
yes, good afternoon. A few questions to begin with, please. We know that the original planning application upon which this appeal is based was submitted in 2018
Yes,
by Frampton's Planning as the then planning agents. Is that correct?
that's correct.
And at some point, you replaced Frampton's as the planning agents in the case
I did 2021.
in 2021. And it was therefore your firm and the team that you had put together, essentially, that submitted the 2021, how should we call them, updates.
That's correct.
Yeah. And one of the things that was not updated was the Frampton's need assessment.
The KKP report was submitted as part of an update to that submission.
Yes, 2023, as I understand it, that was.
No, there was an earlier submission.
The earlier submission?
Yes.
Okay. So by that stage, had you decided that your case so far as surplus to requirements is concerned was based on the twin pillars of, firstly, the spiral of decline of Speedway, and secondly, viability?
The change upon our appointment in relation to the amended scheme that was submitted reflected our assessment of the need to address both elements of, well, paragraph 99 in relation to surplus, but also alternative provision.
Yeah. I mean, if we look at your proof to see how it's put in the executive summary, which is often a good way to understand how the case is constructed. We can see in the executive summary on page 3 in your proof, and thank you very much for numbering the proof in the same page as the PDF numbers. We can see 1, 2, 3, fourth paragraph. The proposals will replace the former Brandon Stadium. Clearly has a lot of history and fond memories, but which has not operated since 2016 and is in a state of disrepair. And then you go on to deal with that. matter, and you say in effect that it's not viable to restore the stadium.
Yes.
But then you also say in the next paragraph, the viability of Speedway as a sport is in question. This is an important consideration to this appeal, as the ongoing prospects of Speedway operating at the site need to be considered alongside the significant cost of making the stadium capable of hosting events, as well as the fact that the site would also need to be purchased. So it seems to me that there are two pillars to your case. One is the decline of Speedway, and the second is viability.
As previously stated, the viability of Speedway is fundamentally linked, is an intrinsic part of the assessment of need.
I understand that. But you will understand, and we'll come to it presently, there's a difference of opinion as to how that policy is interpreted.
Yes.
But just trying to understand the pillars of your case, and then we'll see what policy has to say about them in due course. Yeah. But I'm right, aren't I? There are essentially two pillars to your case. One is the spiral of decline of Speedway, and the other is viability.
In my view, you cannot separate the two. The viability.
All right, there's one pillar of your case, and that one pillar comprises the spiral of decline of Speedway and the viability of the stadium.
The two, in relation to the future of Speedway, the future of the stadium, the need and the demonstration of it being surplus or not, cannot be separated from a consideration of whether it is a viable sport in general and whether the stadium itself, in its state, is a viable prospect to be brought back into beneficial use.
Okay, so in that case, we've got, I'm quite happy to describe the two pillars as viability of Speedway as a sport and then the viability of stadium to be brought back into a use.
Yes.
Yeah, all right. Now, when we are considering the future of Speedway and indeed of stock car racing, do you agree that the views of the national governing bodies are a material consideration to which the inspector should give weight?
They, as users of the sports that are being proposed to be reinstated at the site, are an important consideration for the inspector. They have, however, failed to present any form of national strategy or indeed how that would then be applied at a local level for their intentions in relation to this appeal site.
So you criticise the national governing bodies for not having, in effect, a national strategy?
We heard on day one of this inquiry lots of positive initiatives that are being developed by that body in terms of diversification and looking at broadening users. But there is no plan. There is no stadia strategy. There is nothing before this inquiry that sets out the long-term, short-term, medium-term ambitions of that body to stop what you put as the spiral of decline.
And the absence of such a strategy, how does that bear on how the inspector is to judge whether or not the stadium is surplus to requirements?
We firmly say that that is intrinsically linked with the viability of the sport in general and therefore applied locally to this stadia, given the specific circumstances of this site, which are fundamentally different than some of the other sites that have been referenced during the course of the last week, is a key consideration.
Okay. Now, so far as the weight to be given to the national governing body's view is concerned, you've already just referenced the matters we heard on Tuesday morning.
Yes.
And they came, the matters you're referring to, the evidence you're referring to, is that from Mr. Morris?
That's right.
Could you just have a look at the first page of his statement, his proof, please? CD 16.4.2. Paragraph 1. And just remind ourselves of his credentials.
Yes. It's very impressive.
Yes. I'm minded to describe him in my closing submissions as, for the purposes of this inquiry, the closest that we've got to Mr. Speedway. Would you agree?
His credentials are very impressive.
They are. He is, so far as the evidence before this inquiry is concerned, about Speedway, he is Mr. Speedway, isn't he?
He is Mr. Speedway in terms of the governing body. He is not a stadium operator.
But insofar as there are two pillars to your case, one is whether or not Speedway is a sport in terminal decline, his evidence is wholly relevant to that issue, isn't it?
It is relevant, but as we heard, and there is nothing in the written submission of Philip Morris that sets out a strategy, a plan. There are no numbers in relation to participation or spectators or how that's delivered through stadia, how the grassroots will feed into the Grand Prix series that is now hosted in Cardiff, how the television rights that he spoke very passionately about feed down to the grassroots.
So you think it's all just going to be held centrally and the governing body has no interest in fostering grassroots sport, is that right?
We've heard no evidence as to how they distribute their money.
Oh,
so there is nothing to contradict that statement.
Yeah, well, I don't recall Mr. Morris being pressed on that sort of issue. Now, so far as your case is concerned, where do I find, please, any assessment as to what the local need or demand is at Brandon/Coventry?
Well, as we have set out, the ability to identify participants through the teams. So there has been assessment of the teams that are operating, which is contained in the evidence of KKP. In terms of spectator numbers, if you are adding that into that criterion, then again, we have not been able to identify any categoric information in relation to spectator numbers.
So your defence to the where is your local assessment of demand or need is there isn't sufficient data.
Well, that's correct, and there's been no alternative data presented to this inquiry.
No. So in your judgment, is that form of assessment wholly reliant on data?
There is a quantitative and a qualitative assessment. The combination of both the quantitative information from KKP and Mr. Reedy and the qualitative assessment from Mr. Clark Osborne, a stadium operator and experienced professional in the Speedway arena has reached the conclusion in relation to that point.
So far as Sport England is concerned, do you think their view should be given weight in the case?
They are a non-statutory consultee in this consideration, so their views should be afforded some weight, but again, they are not a statutory consultee.
Okay. All right. Now, can we next please go to your Appendix 1, which, as you explained, is a chronology. And I think you told us it is a chronology with compiled from information supplied to you by the appellant.
That's correct.
And it's in your proof, PDF page 52.
Yes, A2.
It's called a History and Significant Events Review.
Yes.
And we can see the first entry, February 14, recent history, stadium became known for holding speedway racing, stock car / bangers, and until February 14, greyhound racing, following which it lost its license, and that's when greyhound racing bit the dust.
Yes.
Note, it's line 2. The site was openly and widely marketed by GVA, known now as Avison Young, as being suitable for redevelopment or continued use. Marketing first began in 2013. So as far back as 2013, redevelopment for housing was openly being talked about.
Yes, those are in the marketing particulars.
Yeah. And then we get this. It's understood that due to a breach of loan covenants, i.e. default by the owner, NatWest, as mortgagee in possession, had exercised the right to force disposal to recoup monies owed. And we know from elsewhere in the evidence, in effect, the then owner had a series of business loans for other businesses secured on the stadium, which the bank then called in.
Yes.
Yeah. So the bank's forced sale was nothing to do with the operation of the stadium. It was all to do with the stadium was the security for other elements of the owner's business.
The outcome you're referring to, yes, I agree with you, but clearly the ability of that individual to address the financial challenges that he was experiencing at that time cannot be disregarded in relation to the income that was being generated by that site.
Yeah, but the income or the profit and loss of the site wasn't relevant to the bank's decision to force the sale, was it? That was all to do with other business ventures of the owner, which happened to be secured against the stadium.
Yeah, the ability of that individual to address his financial challenges could have been indirectly addressed through any income generated by the stadium.
Yeah, I mean, if I borrow some money from the bank, and you promise the bank in the end that in the event that I default, the bank can come to you for the money, yeah. That's the position here, isn't it?
Yes.
Yeah. Okay. And then we can see line 3. After a protracted marketing campaign, the freehold of the site was bought by your clients.
That's correct.
And in what is described as a bank consensual sale, i.e. the bank had to give permission for your clients to buy it.
That's correct.
Yeah. And as line 4 tells us, a special purpose vehicle was the vehicle, perfectly ordinary commercial arrangement. But what that means is, as the bottom of line 4 tells us is that the stadium is the only thing that Brandon Estates Limited own.
Yes.
Somebody else owns Brandon Estates Limited, but that's by the way.
That's correct.
Yeah. And what we know is that eventually in 2016, the stadium stopped hosting racing.
Yes.
And that upset some stakeholders associated with either participating in or running or watching motorsport at Brandon. And so a campaign group was formed, and they are here at this inquiry as SCS.
Yes.
And we know, although we don't know it from your Appendix 1, but we know from Mr. Hunter's evidence at paragraph 6, at CD 16.2.4, paragraph 4, he inquired, Mr. Hunter, 16.2.4.
I've got it.
No, sorry. Well, I'm looking at the file name for it, which says on my copy 16.2.4. It may have been misnumbered, but it's Mr. Hunter's proof anyway.
Yes, I have it.
Paragraph 4. He inquired, he says, in March 2017 about buying the site. And he visited the site in May. And then on the 7th of May, paragraph 6, he made an offer to buy the stadium. But nothing has been heard. Do you believe him?
Yes, I do believe it.
Right. So that was two efforts, 2017 and 2020. And in 2017, he did hear back. And he heard back his appendix, PDF page 6 of 8. Dear Mr. Hunter, we're the UK lawyers for Brandon Estates. Thank you very much. Our clients have paid a lot of money for Brandon Stadium. And then the 4th paragraph, 5th paragraph, our clients are now in the process of finalising a planning application for housing for the entire site. Our clients are experienced enough and certainly pragmatic enough to know that the most likely outcome of a planning application is that it will be recommended for approval by the planning officers. Pausing there. Correct.
Correct.
But then rejected by the planning committee. Pausing there.
Correct.
Correct. And then this statement, Mr. Hooper. On appeal to the Secretary of State, it is almost certain that the application will be granted. Now, somebody had given those solicitors some planning advice. Was that you, Mr. Hooper?
It was not me. The letter is dated 2017. We were not appointed to this project until 2021.
No, you weren't. But certainly, a bold statement, would you not agree?
It is a bold statement for somebody who's involved in the planning system. Yes, I agree.
Yeah. But that advice seems to have infiltrated the mind of your clients. And I would suggest to you clouded their judgment. Let me give you an example. SCS have said that they would like to recommence Speedway at the stadium in a manner that we have all characterised at this inquiry, without meaning any offence to SCS, I'm sure, as a jumpers for goalposts approach.
Yes.
But they have been unable to get onto the site in order to assess what work might be required for putting up jumpers for goalposts. That's correct, isn't it?
I am not aware of any requests in a general sense. There was a request in relation to the current planning application that is before the authority in relation to the reinstatement of a couple of buildings on the site. There was no reference to the track or the stadia in a general sense. The proposed use was in relation to a museum and a gym. So in the wider context, there has been, as far as I am aware, no request.
Okay, well, I'm not going to go into that any further, but would you agree that in order to be able to present the most cogent evidence, it would be necessary for SCS to have the cooperation of the landowner?
In respect to this inquiry,
Yeah.
they were granted consent to go to site.
Yes. Very recently.
The request was granted within 24 hours of that being put to us. It did come late in the day because the presumption had been made that our rejection of the request to go to site in relation to their current planning application applied to the appeal.
All right.
We put them right. That was not the case, and they could, of course, attend site in relation to the inquiry.
Okay. All right. My learned friend, Mr. Humphreys, can take that further in if necessary. Now, so far as the policy context is concerned, can we please go to the local plan, where we have been to many times, and first of all to HS4C. There is just one matter that we have not ventilated yet, and I think I said it was page 70-something, didn't I? Yes, 72 in the PDF.
Yes. Sorry, which element of the policy?
HS4C.
Yes.
The introductory sentence ends up, should not be built upon unless.
Yes.
And then three criteria, one of which needs to be satisfied.
Yes.
The policy puts the onus on the applicant for planning permission.
Yes.
Right. So that if somebody is relying on the first bullet point, which we have agreed is equivalent to, or precisely the same, in fact, as 99A in the MPPF.
Agreed.
It is for the applicant to clearly show that the land is surplus to requirements.
That is what the policy says, yes.
Yeah. It's not for the applicant to say, well, somebody else must do it.
No, we haven't contended that. We're simply saying that we have undertaken that assessment on the basis of the information we have gathered. There is an absence in relation to speedway and stock car racing for whatever reason in relation to particularly spectator levels. And there has been no information to the contrary of that presented to this inquiry, or at any point during the planning application proposals.
And so far as the current application is concerned, do we agree, which I hope and think we do, that HS4C first bullet point is relevant to the decision that our inspector has to make?
It is relevant, yes.
Yeah. And then we can also agree, can't we, that the third bullet point is also relevant?
We can agree, yes.
Good. And therefore we are agreeing, aren't we, that that paragraph 99A and 99C of the NPPF are relevant?
Correct.
The difference between us as to whether one focuses on participants or spectators doesn't affect the fact that those two subparagraphs of both the policy and the NPPF are relevant.
That's correct.
Yeah. Can you go next, please, to the neighbourhood plan and policy, that's CD 8.3.
Yes.
And policy LF1 on page 44 of 45.
Yes, I have it.
And again, we can agree that this is relevant.
Yes, agreed.
Because Brandon Stadium, brackets presently closed, is a community facility to
Yes.
which expressly this policy applies.
Agreed.
And this is about protecting Brandon as a community facility
Yes.
for the community.
Yes, that is the premise of policy FF1.
For spectators.
For the community.
Yes. And tell me, do most members of the community spend their time riding round the track? Or sorry, did they spend their time, presently closed, riding around the track or watching other people riding around the track?
We don't know because we have no evidence before this inquiry in relation to spectators.
I see. So you think it's likely, do you, that there are more people in the area of the neighbourhood plan who ride speedway bicycles than watch it?
No.
Is that your evidence?
No, that's not what I said. I said we have no evidence. Nobody has presented any evidence as the balance of participants, or where those participants originate from.
Okay.
So I cannot agree with your statement.
But you would agree, would you not, that it is... I mean, if we have a look at the list of community facilities, we have the pub and the village hall and another pub.
Yes.
And the club and the hotel and the stadium.
Yes.
They are all protected for the benefits of people in the community who use them as facilities, rather than for the people who work or perform there.
The policy is not explicit. That's
Well,
your assessment of that, I would say, is a reasonable assessment. But the policy is not explicit in that.
No. I mean, for example, we don't protect pubs for the benefit of the landlord, do we?
No.
No. We don't protect hotels for the benefit of the waitresses.
No.
No. We don't protect the club for the benefit of the secretary.
No.
No. We don't protect the stadium simply for the benefit of the people who ride there. We also protect the stadium for the people who go there to watch.
Yes, in a community sense.
Yeah.
Of the question being the benefit that the stadium back pre-2016, what contribution did that stadium make to the local community? Our assertion is that that benefit has not been demonstrated in terms of the benefit to that local community.
Okay. And therefore, if we go to paragraph 99A, an assessment has been undertaken which has clearly shown the open space buildings or land to be surplus to requirements. That must be surplus to the requirements of both the participants and the spectators. Both would be relevant to a 99A assessment, wouldn't they?
No, I disagree.
You disagree. Yeah. Which are irrelevant?
When reading paragraph 99 and the preceding text at paragraph 98, there is no reference in any paragraph to spectators or to use your link community.
Okay. All right. Let's say for the moment that you are right and the inspector is persuaded about that. In that scenario, you would agree, would you not, that paragraph 93 would be relevant?
In respect of 93A, there is an explicit reference to sport venues. And therefore, 93A, in terms of the planning positively for the provision of sport venues, is relevant to this consideration of this planning application. Clearly, we have before the inspector a proposal for the creation of a new 3G pitch to provide that facility.
Okay. Cut to the chase. 93C and 93D, look at those. Mr. Hooper, please. In the scenario you're postulating, if the spectators' interests are not covered under paragraph 98, then guard against the unnecessary loss of valued facilities, particularly where this would reduce the community's ability to meet its day-to-day needs, and then ensure that the established shops' facilities are able to develop and modernise and are retained for the benefit of the community.
I would question paragraph C as to the contribution that the former stadium made to the day-to-day needs. I would also question the application or the suggestion of it, the need to retain the facility for the benefit of the community. That is not, we have examined that as a prospect in terms of the intentions of the authority, in terms of the resolution that was passed at the end of last year, and in relation to any CPO matters, and it was confirmed that there is nothing on the table as yet.
Okay, so just to check that in Hooper world, paragraph 99 of the framework and HS4C of the local plan are relevant to participants.
Yes.
And LF1 of the neighbourhood plan and paragraph 93 of the framework are relevant to spectators. That's the lie of the land in Hooper world, isn't it?
LF1, yes. Sorry, paragraph 93.
Of the framework. Yeah, for the reasons we've just been discussing.
Well,
You accepted that at least part of 93...
At least part of 93. Yeah. I don't accept the latter two.
No, I know. I'm not going to beat my head against a brick wall, Mr. Hooper. But I just wanted to summarise where we were for the benefit of the inspector's note. All right. So far as viability is concerned, that's expressly a requirement of policy LF1, isn't it?
Yes.
It's no longer needed or viable.
Yes.
So, so you've got a choice of satisfying needed or viable, one of those two.
Yes.
And then it says, and that. So one of those two, and what follows?
And that there is no realistic prospect.
Yeah.
Yeah. Yes.
Of viability being improved.
Yes.
For example, by using the community facility in a different way.
To make it more viable?
Yeah, well, for example, let's use the example of Brandon Stadium. Why not? You've said, see your Appendix 3 and 4, that the stadium is in a state, and particularly the grandstand is in a state, and it is going to cost £13.7 million of somebody's cash to restore it to the state that it was in, or a state fit, so that it can function again as a modern stadium as it was designed to be.
That's correct.
Yeah. SCS have come along and said, well, that's not what we're proposing to do. We're proposing to do jumpers for goalposts.
Yes.
So under LF1, you would have to show that there is no realistic prospect of viability being improved by a jumpers for goalpost approach.
Yes, and as I ran through the evidence earlier, the direct comparison of cost from the RRB assessment versus the SES assessment clearly demonstrates that there is a significant gap between our qualified costs and therefore the viability, the likelihood, let's use the word likelihood, of that facility being able to be brought back online to serve the community.
And we all wrote furiously while you were saying it, Mr. Hooper, and my learned friend Mr. Humphrey. I was a bit worried that I was writing furiously and that I hadn't read this evidence anywhere before. I was comforted by the fact that my learned friend Mr. Humphreys was also writing furiously as if he'd not read it anywhere before. Was that comparison, the comparison of the costs of the jumpers for goalposts scheme, set out anywhere in your written evidence?
No, I have drawn from the RLB assessment that has been before all parties as part of my submission. It is simply looking to apply the jumper for goalposts analogy, which we disagree with. You know, to be clear, we do not agree that that is a feasible, safe way of bringing this site back into beneficial use. And therefore, I was trying to assist the inspector by pointing out that that unqualified assessment that has been provided, as we spoke about earlier in the week, there are significant differences. And therefore, if you applied the jumper for goalposts analogy, and you went down that route, as has been alluded, which is not part of our case, we do not believe that that is a viable prospect, there is significant differences between us and SCS.
Yes. So far as the main issue is concerned, the inspector phrased it as being the viability of reinstating the Speedway Stadium, didn't she?
Yes.
But nobody is actually proposing, so far as I'm aware, to immediately fully reinstate the stadium, are they? Because nobody is proposing to reinstate the main grandstand, for example.
Does that mean it's not a stadium?
No. It's right, isn't it, that what's being suggested by SCS, at least in the short term, is to recommence use of the stadium for sport and recreation.
Yes, in a far more limited capacity.
Yeah, and therefore that's the issue that the inspector needs to wrestle with, isn't it?
Well, that is the proposition that has been put forward by SCS. That is their intention. We have highlighted significant concerns about the fact that their costings are not based on any form of structural survey or through a cost consultant.
I've heard all that. And what the inspector will have to do is, in the words of LF1, she will have to decide whether you have shown that there is no realistic prospect of that happening.
Agreed, that's the test.
Yeah. Now, the other matter of, or a relevant matter for that viability assessment will involve, firstly, the costs of bringing the site into a fit condition physically.
Yes.
And that's what you've been talking about.
Yeah.
But it will also require consideration of the costs of operating or hosting events.
Yes.
And in this regard, would you agree that SCS and its supporters are at least as knowledgeable and experienced as the appellant?
I disagree, because nobody on the part of SCS or anybody who's appeared before this inquiry is a stadium operator. And there is a fundamental difference, as we spoke about this morning, about actually acting as a tenant and a team using a stadia, and somebody that was responsible for everything that goes with the stadium.
Okay. So what they're missing, you say, is a stadium operator?
It is an experienced individual who is able to provide the cost and the requirements that would come with the operation in any capacity. And I would stress that even the jump over goalposts analogy still requires the same level of health and safety in relation to the track and spectators to enable them to get the required licensing from the planning authority, the licensing authority.
And is it your case that that there is no reasonable prospect that they would get such a license?
We have raised doubt that the jump for goalposts analogy, because of the structural concerns that have been raised in the submitted report, that actually the site could be brought back in the lower initial phase that SES have indicated. And certainly there is no health and safety assessment on their part to demonstrate that that is the case.
Have you asked the licensing authority?
In respect of their proposal?
Yeah.
No, we haven't.
Have you commissioned any health and safety evidence about their proposal?
We haven't, but obviously we can read into the structural survey that is submitted, which raises significant concerns about the health and safety risks associated with the current structures. Fundamentally, the grandstand in particular, the proposal is that the grandstand would be hoarded off. And if you read the structural survey, there are significant doubts about whether that is an appropriate form of the stadium being brought back.
But to quote a favourite line of my own friend, Mr. Goatley, where, please, is your evidence that there is no reasonable prospect that the requisite licences and health and safety requirements could not be complied with?
We have not submitted any evidence. We are using the submitted structural survey from a qualified structural engineer to raise significant doubts around the health and safety in the scenario where some of those buildings remain on site during the operation of the track, and the risks of elements of the existing grandstand falling onto the track, falling onto spectators.
I've seen, and I've read the evidence, and I've read the structural report, but the structural report doesn't deal with the issue, does it?
It deals with the structure.
Of boarding up the main grandstand, fencing off the main grandstand, restricting access around the main grandstand.
It doesn't, but it raises concerns around the structure.
It does, yeah.
And how you would deal with that.
Yeah.
And there has been no proposition from SCS about how they would deal with that. There is a reference in the cost plan to hoarding. And there was a suggestion last week that it would be in line with hoarding that one might see in a town or city centre in relation to a building site.
Okay. I think we've probably just got time to deal with one more issue before the lunchtime adjournment. Part of the appellant's viability case is dealing with the stadium and its structures as they are today.
Yes.
And as they are today is, frankly, the stadium is in something of a sorry state.
Yes, it is. Very sorry.
And it is in such a state, at least in substantial measure, because of acts of vandalism by trespassers.
That's correct.
And those vandals achieved access to the site because it was not secure.
We have spent an awful lot of time talking about the court case.
I haven't got to. Who mentioned a court case, Mr. Hooper?
Well, you mentioned failure to secure
Yes.
the sites.
Don't jump ahead of me.
Okay.
Just answer the question. The vandals got access because the site was not secure.
The site, I know you have been to site, you will see that the site is an extremely accessible site.
Yes.
And therefore, yes, there have been challenges in securing the site. Yeah. That is not surprising for anybody that has been to the site and can see the numerous ways in which you can gain access to it. So it is not a surprise to me, in my experience, that the problems that have been experienced here.
Yeah. But as you have foreshadowed, we are now heading towards the court case. And what the court case established was, first of all, the council issued a notice.
Yes.
On the basis that your clients had not secured the site adequately.
Yes.
That went off to the magistrates' court.
Yes.
Where your clients were convicted.
Yes.
And ordered to pay the council's legal costs.
Yes.
The council then decided, then your clients appealed.
Yes.
The council then decided that the measures recently taken by your clients did secure the site adequately.
Yes.
Yeah. And therefore, in effect, the council had succeeded in achieving what it wanted, viz. A secure site.
As far as their actions in relation to the notice, yes. However, incursions continue at the site.
Okay. As a result of that happy state of affairs, both parties dropped hands. The council withdrew the notice and your clients withdrew their appeal.
Yes, the notice was withdrawn. Yes.
So we end up with a state of play as follows, don't we? There is currently no notice extant in respect of the site.
That's correct.
But your clients stand convicted by the magistrates.
That's right. They were convicted, yes.
Yeah. And subject to the order to pay the council's legal costs.
Yes,
Yeah. So that's the state of play.
that is the state of play.
Yeah, very well.
As I say, incursions continue despite the additional security measures that have now been taken.
Yes. But the site has not significantly deteriorated. The damage to the grandstand by fire and so on and so forth, I think was caused before the notice was served.
That's correct.
Yeah. All right. I'm going to suggest to the inspector we have a break for lunch.
Thank you.
Okay, thank you very much, Mr. Richards. Yes, we will have our break for lunch then. So we'll reconvene at 2 o'clock. Thank you. Right, thank you everybody. We are just about on 2 o'clock. So good afternoon to you all, and we are now going to continue with Mr. Richards' cross-examination of Mr. Hooper. Thank you, Mr. Richards.
Right, Mr. Cooper, the skillful art is to make sure you switch on your microphone second and then you don't appear on the screen.
Like 5 minutes of fame, I don't mind.
I now have it down to a T. A couple more topics and then some sweep-up questions. First topic for after lunch. Oh, yes, sorry. First topic for after lunch is going to be NHS. Which I just forgot.
Yeah, not something doubtless to cause indigestion to anyone after lunch. For reasons which doubtless are obscure, for whatever reason, my junior was contacted by the solicitor for the NHS over lunchtime and indicated that her witness may not be available for those particular dates. What I indicated to her, because I particularly indicated I did not wish to become an involuntary postbox for these purposes, it was in order to give them as much advance information as possible rather than for us to become the conduit for discussion. That certainly so far as the principal parties are concerned, they do not wish to see any more delay really than that which is been going to arise anyway. And I left it with her that she may need to look to see whether or not she finds someone else other than Mr. Gilkes to give that evidence. She was otherwise suggesting that they would turn up tomorrow, and I said, well, that's a matter for you, but you've already indicated the way that you wish matters to be dealt with. And so I left it with her to then communicate with PINS and with all of the parties as to what's proposed. But I did give the impression, it would be fair to relate, I gave the impression that certainly as far as the principal parties are concerned, they would not wish it to go beyond the 2 dates that have been identified, but that you had not fixed those dates. But in the light of anything that comes back from them, then obviously that would be a matter upon which we may be making submissions to you upon in terms of fixing those dates. So I hope that has fairly related what has transpired. It may well be that there is further correspondence this afternoon, and obviously we'll see what that is. So if that is further correspondence, that will be the context in which that arises.
Okay, that's helpful, Mr. Goatley, thank you. Yes, we'll just await and see what further outcome and further feedback we have from the NHS party. Thank you.
Yes, I mean, so far as we're concerned, by the time we finish everything else tomorrow, you've got to adjourn the inquiry to a date. And at the moment, that looks like being the 8th of November. And even if we haven't agreed anything else, it can still be the 8th of November. And then if that's to be changed, it can be done administratively in the meantime. But when we adjourn, we have to adjourn to a date. As I understand the rules, but
well,
you probably
that's right. That's usually the case. So yes, we'll just wait and see what happens over the next few hours and take it from there. All right.
Good.
Thank
The only thing which I'd additionally observe as well with regard to the issue on the Section 106 is that we had partly suggested or floated the idea of splitting between the NHS and other matters. I think if this was a matter of a day or two, then I think I would probably stay with that. By reason of the fact that it's going to be a prolonged period of time, I think it is better for the 106 to be dealt with as a single session with all matters.
Okay, I'm open to advice really on that. I mean, I'm happy to deal with it either way. But
Well, there is an advantage in that, because I'm about to
There
ask
is.
some questions on the topic on the lines of what happens if. And it may be that rather like the £100,000 dowry appeared as a late amendment, that there may be other late amendments as a result of any questions I ask. So that could only be helpful.
no, I'm fine with that. Yeah, that's no problem at all. Yeah, okay then. So, if that's everything, then Mr. Richards, do you want to continue, please?
Thank you. Mr. Hooper. Yes, before we get to what happens if, Well, yeah, let's deal with that at the first what happens if, which is what happens if this appeal is lost. Now, you have told us both in your written evidence, see paragraph 5.71, the inspector's note, that the council's resolution of the 14th of December 2022 has not been acted upon. So if we look at your appendix 10, which is PDF page 185 in your proof bundle,
Sorry, the page reference.
185, it's A135 internally, if that's more helpful, but it's PDF page 185. So these are the minutes of the full council meeting of the 14th of December 2022, which you have helpfully provided for us, and it's paragraph 8, notice of motion. The council recognises the importance of the sporting heritage within the borough, not only in respect of the game of rugby, but also to other long established and well-supported sports associated with Brandon Stadium. We therefore request that following the overwhelming public desire to reopen Brandon Stadium, this council explores options available to bring Brandon Stadium back into use and any likely public advantages to the local and wider communities should this be achievable. That's not, as several observers have pointed out, for example, a resolution to use CPO powers, is it?
No.
It's simply a resolution to explore what options there might be for reopening the stadium.
Yes.
If planning permission is granted for housing and a 3G pitch, there won't be any options, will there? Because your clients will simply implement the permission.
I would assume so, yes.
Yeah. Or sell it to somebody who will.
They won't. There is a development partner on board to start building.
Okay. If the appeal, however, is dismissed, would your clients then be interested in speaking to interested parties who would be wanting to explore reopening the stadium?
I don't believe so, no.
You don't believe so? Okay. That's because they simply don't believe that anybody could viably do so.
That's correct.
Yeah. And because, obviously, they want to, if they can, get a planning permission for an alternative use that realises a greater value.
Yes.
So your clients would not view the dismissal of this appeal on, for instance, grounds that it had not been demonstrated that the stadium was surplus to requirements, on the basis that included the interest of SCS. The inspector found that, in effect, that SCS's interest, to all intents and purposes, ought to be taken further because it could not be said at this stage that it was surplus to requirements. Your clients would simply ignore that, would they?
I can't speak on behalf of my clients.
But you've told us that even if this appeal is lost, that they simply wouldn't be interested.
The discussions to date, in a scenario where we are going through a process to secure the planning consent they've been trying to secure since 2018 is their intention is to implement the consent.
In other words, this is one of those cases where the parties are in their trenches and are knocking 7 bells out of each other. But if the goalposts move, then the goalposts move, and there may be open room for further discussions.
Not necessarily, Mr. Richards. I think the suggestion in the Cabinet report, I think, is a little mischievous in that I'm not aware of any of actions that have been undertaken since that on the 5th of December last year. Yes. Nothing has been progressed with my client in respect of that matter.
No.
And it could have been.
No. That maybe it's because, as you observed, Mr. Hooper, the council's focus has been on the appeal.
Well, as has ours, and the firm intent that we believe, as per the recommendation from this authority's officers, that planning consent should be forthcoming on this site.
Yeah. All right. Okay. The next topic is relevant to main issues 4 and 5, which is the need for the 3G pitch and the benefits balance. The worst of all worlds, wouldn't it, would be if the stadium was lost, was replaced by houses and the 3G pitch, and then the 3G pitch failed.
That would be a negative outcome, yes.
That would be the worst of all worlds.
I would disagree with that because the case does not hinge solely on the provision of a 3G pitch.
In other words, the way that your case has been put at this inquiry is that the prospects of that situation arising are not significant.
Not just my evidence, but the evidence of John Eadie, who has undertaken the business plan, as he does nationally on such schemes.
Yeah. But there will be a dowry, as described by my learned friend, Mr. Goatley.
That's correct.
Is that the £100,000 commuted sum referred to in the 106 at the moment?
It is, yes.
It is, yes. As I understand it, that dowry applies in the event that the management company... Well, let's just have a look and see. Have you got core document?
Has that been added to the core doc?
Yeah, it has.
Okay.
Whisper in my ear. 17.1. Thank you. And it's page, it's not a PDF, it's a Word document, page 40, internal page 36, paragraph 4.5.
Sorry, which page?
Internal 36, paragraph 4.5.
Yes.
The preceding paragraphs are all about the council being first dibs to take control of the 3G pitch.
Yes.
And if the council doesn't want to avail itself of the opportunity to do so, then the next option is a management company.
That's correct.
And then 4.5 says, if the sports pitch is to be transferred to a management company, then the owner shall transfer the pitch to the management company subject to the following 4.5.4, payment of the commuted sum.
Yes.
So if it goes to a management company, it comes with £100,000 worth of dowry.
That's correct.
Yeah. So that is one safety net.
It is.
And then the other safety net, as I understand it, is 4.6. in the event that the management company goes into liquidation or otherwise ceases to exist, and a replacement management company is not immediately put into place, then the council may, on reasonable written notice, enter the sports pitch with such personnel and equipment as is reasonably necessary to ensure performance of the obligations, and so on.
Yes.
And then it says over the page, well, at least on mine, and may carry out any works it considers reasonably necessary to maintain or make good any defect or damage or reinstate any management company functions as it shall be entitled, and it shall be entitled to full reimbursement by the management company of all reasonable costs and expenses incurred in so doing.
Yes.
That would be from the management company that's just gone into liquidation, would it?
It's going to be one of my questions in the 106 debate.
Yeah. So, you may not have the answer now, and I said fairly and reasonably that I would ask you some questions about it so that there might be an opportunity for further reflection. Once Mr. Gately had said and very reasonably, that there might be some benefit for that pause.
I agree. Clearly, the drafting does need some work. It is not, clearly the intention is, as per Mr. Eadie's suggestion, of a dowry that would transfer.
Yeah, the interest is of sufficient safety nets, because
yes.
You and I agree that where we don't want to be is with no stadium and nobody running a properly maintained 3G pitch, and it becomes a white elephant.
3G pitch, yes.
Yeah, good. But the intention of at the moment of the appellant, Brandon Estates, is to put itself into a position where, in reasonably short order, the appellant, ceases to have any responsibility for the pitch.
It transfers to a management company who are more suited to the management and operation of that pitch.
Yeah.
And we heard from Mr. Eadie earlier in the week around the options about who that might be.
Yes. One such option being Sky Blues in the community.
That's correct.
Yeah. Okay. Because in effect, in planning terms, we know that the Frampton's planning application had all its paragraph 99 eggs in the basket of paragraph 99A, didn't it?
You could put it like that, yes.
Yeah. And then when you became involved, 99C, perhaps as a result of the musings of the White Young Green report.
The evolution through the progress of the planning application.
Yeah. And in effect, the 3G pitch enables, no, not enables, but the 3G pitch helps deliver the housing.
In what sense?
Well, the original application was for 137 houses, now down to 124, plus a 3G pitch.
You mean in terms of delivers it in the context of securing a planning consent?
Yes.
Well, clearly we're not just reliant on strand C,
No.
paragraph 99.
No.
So there was a scenario, and we are presenting in both A and C.
Yes. And even if the inspector decides that A is met and C is not, the 3G pitch still has to be delivered.
Yes. Yeah. It's not. We wouldn't take it off the table. No, it is an integral part of the planning application.
But in effect, this is a housing-led redevelopment of the stadium site, including its car park.
It is a mixed-use development, I would argue.
You would argue it's a mixed-use development. You don't think it's housing-led. All right. Now, some other minor matters. Planning permissions that might be needed. I think you and I agree that planning permission would be needed to demolish the grandstand.
Agreed.
And planning permission would be needed to erect a replacement grandstand.
Agreed.
To repair the track would not require planning permission, would it?
To the extent of my knowledge of what would go into repairing the track, I agree, but I do not have the details ahead of me of what that would entail.
Repairing the terraces, would that need planning permission?
If you look at the structural survey, there would be structural works required to some of those terraces.
Okay.
And therefore we are straying into the realms of where there may require a planning consent.
I understand. But insofar as that there is no immediate plans to demolish the grandstand, and if planning permission was required to demolish the grandstand on the basis that it was so structurally unsound that it had to go before anybody could be safely allowed onto any other part of the site to watch or participate in motorsport, then that planning permission would be likely to be forthcoming, wouldn't it?
Yes, I believe so.
And there wouldn't be any condition on the planning permission to demolish the grandstand that said in terms, you can have planning permission to demolish the grandstand on condition that that motor racing was limited to a certain number of days or certain number of hours.
I agree that's unlikely.
Yeah. The same too must apply, mustn't it, to any planning permission to replace the grandstand. It could have conditions attached to the operation of the grandstand and the use of the grandstand, but the use of the track is already lawful.
I question that on the basis that the grandstands, as part of the wider planning unit on that site, we believe would all need to be subject to a new application to cover those elements.
But racing can resume without planning permission.
Well, we haven't seen the jumpers for goalposts solution is with the terraces that we're talking about, where the structural survey that is submitted as part of my evidence suggests that it is not just a lick of paint that is required. And therefore I am saying, I believe we are starting to stray into works that would require planning consent. We're talking about the pits as well. So the erection of pits, of revised pits as part of the proposal.
Okay. But even if there were other planning permissions required for structures, the conditions for those, for the erection of those structures would have to reasonably